Um, David, I'm starting. So, good morning, everybody. We will start. We will start with the presence of a few members of the Parliament for the moment being. Thanks, Mr. Salavrakos, for being here. And but with the presence of the petitioners.
Who are arriving in large numbers.
But, David, this is... So I will start with some chairman's notes. Well, this is going to be a long 3-day meeting, mainly on human rights and child protection, but also environment and competition. Many petitioners are here, so I would really ask them to be short in their interventions, as well those coming from the members of the committee. Item 1 relates to the adoption of the agenda. So I would like to draw your attention that number 21, item 21, is not going to be included. It has been postponed until after the elections. So you also have to, we also have to agree with the minutes of January. If there is no objection, then the minutes may be considered as approved. The annex to the chairman's note has been distributed, and as no objections were received, it may also be approved and annexed to the minutes of this meeting. Members are invited to note that on Thursday, April the 10th, there will be a public hearing on the second successful European Citizens Initiative. The lead committee on this is the Legal Affairs Committee, and Peti is associated with the organization of the hearing. Other committees involved are Libe, Envy, Ferme, and Droit. The coordinators will discuss this and report back tomorrow. So let's, if there is no any other announcement, we start with number 5. I beg your pardon. Number 5.
Number 5.
No, number 5.
Number 5.
No, number 4.
Mr. Wieland has a...
Oh, sorry.
Ja, Frau Vorsitzende. Wenn ein anderweitiger Wunsch eingeht, habe ich entscheidet.
Can you hear the English booth now? Okay, so we need to decide, and apologies for the technical issues there, but we'll continue. And we need to work out what the procedure is. We need to all be aware of whether it's admissible or not admissible. So if I don't, then I assume that that's already been decided with the whole committee because there aren't any objections. And then if I do have cases where it's suggested that it should be inadmissible, then I can't imagine that without having a further procedural step, we can't suddenly have a petition being admissible. Even if the Secretariat makes a decision, we can't have a chair making a decision. That's my view, and I've been here for quite a few years now, since 1997, in fact. And we need to have the whole committee saying that we're correcting this decision. Now I can see that for next meeting on the agenda, we suddenly got petitions on the agenda where for weeks and months it had been written that the petition was inadmissible. Now I think that that is a major violation of the rules that are set out or that have become practice over the years. And that's been the case for a long time. And I don't think that I could leave that without commenting on it. I think we need to look at the agenda of next meeting, and if the procedure that I've flagged up here, well, if that's not changed, I'd like to have some clarification about how we're actually going to deal with such cases. Because otherwise there's no point in having those suggestions because we're not following the right procedure.
Would you be satisfied with discussing this intervention of yours, this complaint of yours, during the coordinators meeting? Have an answer in next meeting, or would you like an immediate one?
Well, it's different.
Well, if we deviate from the rules, well, then I could see that. Well, we'd have to look at that. We can perhaps see what the coordinators would say on the matter. We could come back to that in any case. But as I see it, the procedure here, if it's not correct or if we deviate from it for no reason, then I think we need to stick to the rules until they're changed.
Okay, it's already written. Your question is already written in the minutes. So I hope you're going to have an immediate answer to your complaint, to your intervention. Okay? Are you satisfied with it? Thank you. Item 5 now, concerning adoption and communication with the child. The petitioners are present, so I would like Mr. Klaus Zinser to present the case. Thank you.
Okay. Good morning. It's not on adoption, it's on my child who is in UK. So let me start. Good morning. My name is Klaus Zinser. I'm the petitioner of 12/29/2013 requesting contact to my child. Since my child has been brought initially to UK in June 2009 at the age of 5 until now, when he is nearly 10, he has spent nearly all time in UK. When he was brought to UK, the stay was limited for around 1 year. Therefore, I had a Brussels 2A recognized court order for 2 days a month contact and additionally 2 one-week holidays during summer and winter. Not knowing the UK legal system and soon realizing that child and mother were not at the given address, I ended up using privately paid lawyers. Except a court-ordered contact session supervised from a social worker for less than an hour on 30th October 2009 in a shopping center 200 kilometers away from the alleged address, I have not seen my child at all during this time. ending up with legal bills and requested payments of in total £18,000 within 4 months. I had to stop legal proceedings in November 2009. As there was no contact at all, I got a child returned to Malta under the Hague Child Abduction Agreements in February 2011. This was on legal aid, where my lawyers made £52,000 of taxpayers' money. During this time, there were roughly 3 to 4 court hearings in UK. Instead of in total 120 hours regular contact plus 2 weeks in summer and winter holidays a year, I had less than 1 hour of supervised contact in these 2 years. To the £52,000 legal aid, it's realistic that additional £30,000 were spent privately from father and mother in legal services. When my child was back in UK in October 2011, I had registered a different family court order from Malta from December 2011 with joint custody and 5 days contact a month in March 2012, according to Brussels 2A. In April 2013, when I had employed a social worker to make contact happen, the UK High Court made an ex parte decision at the request of the mother, throwing the Brussels 2A order for contact into the bin whilst I was flying from Germany to UK. Up to now, my child and I should have been together for 60 days and nights per year starting from March 2012. Not one moment of contact has been allowed to take place despite of Maltese order being legitimately registered in the UK under Brussels 2A. Starting from 2012, there were 10 court hearings of in total 15 days in UK. Whilst I could not afford lawyers and was presenting the case on my own, others were hugely funded by UK taxpayer. The mother and the High Court legal services have received, that's very conservative, in total a minimum of £122,000 of UK taxpayers' money. Soon after Brussels 2A order was factually thrown into the bin, in June 2013, when UK has taken jurisdiction against the wishes of the Maltese Family Court and the father, because of the delays, I had to start appeal proceedings which led to a return of the case to UK High Court to correct the violation of Article 8 Human Rights Act ordered by Lord Justice Ryder. Right now I have not seen my child. I have seen him last without the mother in May 2009 at the age of nearly 5 in Malta. In total, since 2009, minimum £175,000 public money plus £30,000 private money was spent in legal services in the UK. Not even 1 penny of this money has been spent on therapy for the child. Instead of seeing my child for in total 2 months every year, 2011 order from Malta, I have been blocked by UK and the mother from seeing him. I request from the Parliament proper support that contact between me and my child can take place. Further, all this spending should be reviewed in detail. Also, it should be clarified why UK does not fulfill international agreements. Therefore, I would like to quote a statement from the Legal Department of the EU Commission. I quote, "If there is evidence in breach of European Union law, this Commission should open infringement proceedings against the Member State to the EU Court of Justice." Further, that's end of quote, "I would like to see the Maltese decision for 5 days contact and joint custody brought back into an order." Okay. If you need more details, next to me is Vincent McGovern from Families Need Fathers in London, who guided me through the UK court proceedings, and he had 4 UK petitions at the UK Parliament with ombudsman investigations, which were all in his favour. Thank you.
Thank you very much. We will first ask the Commission to give us an answer, and then possibly your lawyer will reply. Thank you. So, Mrs. All right. Mrs. Serdinska from.
Thank you very much. Thank you very much, Chair. The case of Mr. Zinser is known to the Commission, as he wrote several times, submitting some of the documents. I refer now back to the letters sent to Mr. Zinser in the past, responding to his claims. However, I will limit myself to the assessment or the reference made to Brussels IIb's regulation, which is Union's law. The Commission cannot assess or take any position on the spendings or financial matters that the petitioner is relating to. It's a question outside the scope of the regulation. Now, turning to the details of the case, or to the details of the claim, indeed, access rights and custody rights fall under Brussels IIb's regulation in cross-border context. However, this regulation is to set the jurisdiction rules, recognition and enforcement of such a judgment. This has been said, it means, or in particular, it means that under this regulation you will find the court responsible to hear the case, and there are rules to facilitate recognition and enforcement. And further, for the enforcement procedure itself, this regulation provides or refers to the national law. So the enforcement itself of any access rights judgment brought from the other member state will be enforced in line with the national law. In the case referred here, it will be under the English law. So in the past, we as said, the petitioner contacted us, and we explained basically the rules of Brussels IIb's regulation. We of course regret very much to hear the difficulties that the petitioner is facing when trying to enforce the access rights order he had from Malta. But as said, we took also, we were provided with the British judgment or English judgment, in which it has been stated that the petitioner had not issued an application with regard to how he would like to enforce the order of the Maltese courts through committal or any other proceedings. So this brought us, so to say, or gave us indication that the matter is around the enforcement of this order in line with the national UK procedure. And therefore we do not, so to say, see much possibilities of assessing if there were any, let me say, mistakes in this procedure or something went wrong. It's just impossible for the Commission to assess the national procedure. This would be basically all from our side. Thank you.
Mr. Wieland.
Ja, vielen Dank.
Yes, thank you very much. Of course, I don't know the case in all its details, but at the moment, I'm not active as a lawyer, but I did practice family law, but there were very few international cases. And I'd just like to say that the opinion of the Commission doesn't shed much light on this, because we've got the documents here as part of the dossier, and the petition has already been put forward to the Commission, but the case wasn't looked at in more depth, and the Commission says that they answered the petitioner. Well, I'd just like to put a question mark above that. In what manner did the Commission reply to the petitioner? Now we need to look at how that has been assessed specifically. that there's been a defensive interpretation of European regulations. I can't assess national legislation. Therefore, if we look at the enforcement of those agreements, if that's done under national law, well, we can't change national law so that someone who isn't aware of this field, with the best will in the world, to make that accessible. It's very complex to make those requests. For instance, there's different timings and so on. There's different things that you need to submit. And it just needs to be clear that next time that will be recognised by national law. And we try to actively help as much as possible to make sure that the valid legislation is applied, irrespective of whether the subject of an order is put to the national court or the court where the order is issued once more. And I believe that the Commission has done too little. You certainly can't assess what is done with public funds and the legislation. But if the petitioner says that the other party received public help, legal aid, and they didn't, then there's something that doesn't fall under Brussels II, but the general rules of the internal market with discrimination. And that the petitioner, as a citizen of the EU, would mean that his rights were violated. Therefore, perhaps we need less of a defensive position from the Commission. I would have expected that if I read the documents. I think we still should say that I don't know, I can't do much if everything's in order, but I don't think you did that. I think we need to help citizens.
Ευχαριστώ πολύ κύριε Βίλαν και για την...
Thank you very much. Thank you for explaining the human rights dimension of the inequality issue. Yes, please.
Just continuing the question of Mr. Wieland, I would like to ask the Commission to answer which concrete steps did you undertake concerning to that petition, because as far as I understand, you have restricted yourself with the contacts with the petitioner. But what about authorities? So maybe you can provide us with the answer. The second one, Commission is also, as far as I understand, your task has to propose new legislation, and whether you have driven out some conclusions from existence of these cross-border cases which we are looking today. Which steps in new EU legislation are you ready to propose to resolve this conflict of national regulations and national legislation when it concerns cross-border cases, when as far as we understand is just the problem we are raising today.
Thank you. In the case referred to, we have been only in contact with Mr. Zinzer. We asked him to submit the relevant documentation, and in particular the judgments issued by the courts, the Maltese and the British courts in this case. Briefly to the second question you asked about what about new legislation, I would like to inform that Brussels IIb's regulation will be reviewed shortly. We are of course aware of the problems of enforcement itself, in particular in the family law area. And it's not only let me say, the British system, and as we face, so to say, similar claims from any other EU country. So it would look to us that, or it would seem to us that the enforcement procedure deserves, so to say, further looking into this, so to make available for citizens to, so to say, to getting the final result, and not only, so to say, a middle-term result, just to direct to the court and say, so to say, you go there. We understand that, of course, the citizen will only be benefiting from the EU rules if he will, so to say, have the final results in terms of enforced judgment. The Commission is now undertaking the evaluation of the regulation. It will publish soon an application report where we also refer to the problems with enforcement in family matters, in parental responsibility matters. And as a next step, it will also assess the necessity of undertaking any or proposing any amendments to this instrument, with the view also of making the enforcement under this regulation effective. Thank you.
Κύριε Βίλαντ, πολύ σύντομα παρακαλώ.
Yes, dear colleague, please speak very briefly so that we can also give the floor to the other party.
Well, it will be very brief. It will be very brief. It's exactly what we thought would happen. The Commission's job is not to start a correspondence with the petitioner. They're supposed to be here to protect the treaties. And if we're saying that it's a violation of the spirit of the treaty, then we must at least ask some critical questions of the country in question, the country which is dealing with this. It's just... It's not a question of what the courts decide, it's whether what happens between the different courts, the one in Malta and the one in the UK, is correct. There's been a petition here, and the Commission has dealt with this in other cases when there's been companies to have penalties imposed against them because of major infringements, but in this case they're not doing it, and the Brussels agreement, the point of it is not being achieved. And I will refer to the previous point as well. The petitioner has claimed that, or has asked for the data about himself and the child not to be published, and in similar cases where we've had all sorts of recordings used, I mean, this violates the interests of the petitioner and of his child.
Κύριε Βίλαντ, έχετε απόλυτο δίκιο.
You were brief, Mr. Wieland, and you're completely right that the role of the Commission needs to be fought for to a greater extent. That's something that we often don't see taking place in the Petitions Committee. Mr. McGovern, did you want to say something concerning this?
To add something, but only 1 minute, please. There is so much waiting for us.
Thank you. My name is Elson McGovern. I am the chair of Central and North London branches of Families Need Fathers, and Klaus approached us looking for help in this matter. I have also had 4 ombudsman's inquiries with findings in my favour against institutional, what I call child endangering gender discrimination within the UK social, children's and family court services. On this significant matter of enforcement, I think it is very important that all the Commission understand that in 2011 in the UK there were only 53 successful committal proceedings for enforcement in the UK. Reference Hansard, the House of Commons log. So effectively there is no enforcement. It is not possible for Mr. Zinzer to bring about enforcement. I could, if I was allowed another 2 moments, explain the institutional systems that prevents people bringing about enforcement, if the Commission will be kind enough to allow me 2 minutes.
If you submitted this in writing, that would be more helpful, I think, because there are so many similar cases we have to deal with. Okay, please submit this in writing. If you can do it today. Okay, thank you.
Thank you.
To item number 6, Mrs. Lila Brice, or Brice.
Excuse me, Chair. I would have expected that the Commission gives another short response what they are going to do now. I mean, we saw the case, we complained, and there is no second reply from the Commission. I want to have something like a promise what the Commission now is intended to do.
All right, yeah. I will ask for you. So, what is the Commission going to do immediately?
Well, immediately, I hope you don't expect me to go to UK on my own. But We will need to look at the case, of course, once more and see if indeed to help the citizen who did not, so to say, could not successfully enforce this, to see if from the Commission side any authorities, a part of the courts, can be contacted to see maybe social services who are involved in the enforcement procedure. To see if they could provide more information why in this, so to say, long term it was not possible to enforce this decision. So we are, of course, we are happy to look again at this case, and we were also informing Mr. Sinzer that if there are any additional information which would help assess, so to say, if there was an infringement of EU rules, we would be happy to look at the case again. This goes without saying. For this petition and any other petition in these matters.
No, this is not very satisfactory, but anyway, Mr. Iturgais.
Mire, señora, igual no se tiene que... Igual no se tiene que ir...
I'm not sure that it's just a United Kingdom. Maybe you didn't need to come here because if you're not going to provide any solution, I think your comments are completely irrelevant. So if you're coming here, you're coming not just to provide some comments, but in order to try to solve problems and provide answers and not excuses like the ones that you have just made. So we're expecting more and more immediately, even from today. And now we move on to the next position by Mrs. Lila Bryce. Well, the petitioners now have the floor.
We don't have any time. You'll intervene later. From Latvia, please do.
Thank you. My child, a Latvian citizen, Catherine Bryce, also known as Katja, date of birth 30th of April 2008, was removed from my care against my wish unlawfully on 5th of March 2010 based on a document called Section 20, which is not valid. It is breach of the public law outlined to ask Parliament to sign the Section 20 in the manner the local authority of Merton did. The local authority should, at this point, invite the parent to a formal pre-proceedings meeting with his or her solicitor. On that meeting, it would be appropriate to seek consent to Section 20 voluntary accommodation, where this is deemed appropriate and where the parent has been able to benefit from legal advice. The Section 20 agreement was illegally obtained in bad faith and through blatant lying and mispresentation, stating it was for medical and health reasons with respect to Catherine Bryce. Moreover, the Merton were clear about my poor English on that moment, but there was no interpreter, so I badly understood what was going on. The local authority of Merton breached my children's human rights as my older daughters has never who was 18 on that day. She's never been considered as a potential carer for her little sister. It is not a legal valid agreement. It doesn't follow contract law, and it wasn't signed by Merton, not witnessed, no interpreter was provided, and it doesn't clarify or specify Merton's obligations with respect to my daughter. I revoked the section on numerous occasions by email, text and orally. The London Borough of Merton blatantly ignored these demands. The local authority of Merton wrote in the agreement that a notice period of 48 hours should be given. That is illegal and breach of the law. My daughter was placed in a non-Russian speaking environment, and since her first language was Russian, she consequently no longer speaks Russian, which led to speech delay. This is to be a serious violation of her human rights, not to speak on her heritage and background. A local authority has a duty to consider a child's heritage, culture, language and religion. When I informed the local authority of Merton I was moving to a different borough, care proceedings were immediately initiated. That is a gross violation with the freedom of movement as described in European law. The local authority of Merton frequently mentions my financial position in various documents. It is not a crime to be financially challenged, and it is absolutely not a legal reason to put my daughter for forced adoption. My daughter was abused emotionally and physically in care on a regular basis, but the local authority would ignore all my complaints and requests to investigate. For instance, on 23rd of March 2011, Catherine became a subject of car accident when was in a car driven by the contact supervisor. The local authority of Merton ignored all my formal requests to the accident and refused to investigate. Merton refused to provide me any information about the car accident. Moreover, my daughter hasn't been taken to hospital for check. On 17th of June 2011, Catherine was taken by her foster care to St. Helier's Hospital emergency department with head injury. My daughter was a subject of Section 20, which doesn't give parental rights to anybody else, and the duty of the local authority is to inform the parent about every single accident related to the child, which the local authority didn't. I was not informed about the accident nor given explanation about the nature of head injury. My daughter was abused by other foster children at foster care place as well as by her classmates. She would be brought to the contact center with bruises on many occasions. None of my requests would be considered. My daughter was also abused emotionally by being told by social workers such as Ruth Wilkinson that her mother wouldn't love her and she will abandon her shortly. On 3rd of November 2010, rehabilitation plan Catherine was issued. She was supposed to get reunited with her family by 21st of November 2010. On 4th of November 2010, I received an email from Ruth Wilkinson who introduced herself as a new social worker allocated to our case. Despite the rehabilitation plan, Ruth Wilkinson had referred my daughter to another hospital, the Queen Mary's Hospital for Children, to be assessed by Dr. Nicholas Silva, Associate Specialist and Medical Advisor to the Adoption and Permanency Panel, London Borough of Merton, the member of British Association of Fostering and Adoption, which clearly says that the Merton decided not to return my daughter to her family, but instead to put her out for adoption against my and his sister's wish. Moreover, the local authority of Merton didn't inform me about such referral, nor asked my consent. The St. Helier's Hospital appears to be among the members of the European Organ Transplant Society. Jane Farrer, social worker for the Adoption Agency of Merton, says, "You are a good mother, you have done everything we told you, but life is unfair, and in your case, life is very unfair. You need to be realistic. In my practice, judge had never made decision against social services. You must be prepared to the worst." The notice of final court hearing in respect of my child clearly reflects and proves that Merton would not doubt in the outcome. The note of the court states you need not attend the hearing. Adoption panel, a meeting. In terms of adoption panel meeting, a child cannot be put before the adoption panel without parents' consent if the child is not subject to an interim or full care order obtained through the court. Basically, when a child is subject of the Section 20 voluntary accommodation, the parent has parental rights, and this is not shared with the local authority. So the local authority would have to ask the parent permission to take any action at all. The local authority of Merton sent to me the letter from foster care stating that my daughter was deeply traumatized when she was told about moving to adopters. The local authority of Merton interim that I was inflicting distress and causing my daughter to be ill because I was exercising my legal rights in order to ensure the return of Catherine to my care. That argument has no validity whatsoever. On the contrary, Catherine has stated again and again that she wishes to be reunited with her mother and sister. I contend that is the local authority of Merton that has caused potentially irreparable harm and distress to my child. Dr. Silva, on his report on 25th of February 2013, states, Catherine has been smashing things in her room and has been tearful. She now knows that she is moving on to a doctor's and her emotional behavior has been of some concern. I understand that her mother has been given leave to appeal. If this is going to mean further uncertainty for Catherine, then this will need to be supported and some form of emotional support should be considered. I suggest that this is discussed with KMHS. So the local authority break up my family, causes unbearable trauma to both my daughters, and then put her into child and adolescent mental health services that are supposed to deal those struggling with mental difficulties. In the letter related to the judicial review, the local authority of Merton essentially states that even if the law has been breached, it doesn't matter and it is deemed insignificant. We, the local authority of Merton, are above the law. We can conduct ourselves as we wish and please. Nobody will hold us accountable. However, there is a rule of law in the UK, and even local authorities have to obey and abide them. The London Borough of Merton has a propensity to threaten, intimidate and bully my family. This has been demonstrated on numerous occasions. I highlight that adoption agency must not act in breach on European Convention rights, but in case of my child, the adoption agency of Merton did act this way. The local authority of Merton and Kafkas falsely and erroneously stated that I have never revoked the Section 20 agreement. Given so much importance, credence to the... I have revoked this agreement on numerous occasions. Additionally, given so much importance, credence to the expert witness and his mediocre medical legal report and testimony is a fallacy. Additionally, the expert witness, Derek Blinko, appointed by Kafkas, was not ordered to assess myself and could not under any circumstances reach those conclusions after a 75-minute contact between mother and child. In addition, given credence or believing in attachment disorder, which is a catch-all diagnosis of the sort commonly identified with QAC practice, is a travesty of justice. The term attachment has no broadly agreed on precise meaning. The term is not part of any accepted standard nosology or system for classifying behavioral or mental disorders, such as the Diagnostic and Statistical Manual of Diseases. Officially, there is no such disorder. The local authority of Merton has blatantly and willfully disregarded the law statutory guidelines, the Human Rights Act and the Equality Act, which with respect to me and my daughter Catherine Bryce, as well as her sister Maya Zargaryan. In addition, they have misrepresented material facts to the courts. The local authority of Merton committed a crime classified by the Rome Statute as genocide, Article 6. In point E, forcibly transferring children of the group to another group. And crime against humanity, Article 7. In point D, deportation or forcible transfer of population. In point I, enforced disappearance of person. In point K, other inhuman acts of a similar character intentionally causing great suffering or serious injury to body or to mental or physical health. As my little daughter became a subject of forced adoption and her mother and sister are not allowed even to know her whereabouts or whether she is alive. An unbearable suffering for entire family may only be compared with life sentence. Parts E. Enslavement means the exercise of any of all of the powers attaching to the right.
Excuse me. Please do complete. We don't have time.
Okay. Well, I would like to, in conclusion, I would like to highlight that the High Court Family Judge Sir Munby states that judge and social workers must not longer keep their decision. They cannot make decision about the fates of foreign children, and they must not longer keep their decision secret or try to gag foreign media either, which Martin did with support of court twice. I was given 2 injunction orders stating that I will be sent to prison in the event if I share my case. In conclusion, I would like to highlight that the local authority of Merton became a subject of corruption scandal when senior managers were involved, and I believe that my child's case is a great proof of that, and I would like to a committee on petition to consider this case as a matter of urgency and to try to investigate. Thank you very much.
We'll try our best. There is a similar, this is not Europe, I must say, Mrs. Zargarjana. It's the same or similar case, please.
Sorry, I just wanted to say that obviously we're a family unit, but I would like to say that as a sister of Catherine, I'm deeply concerned at how this case was dealt with. You know, I was not given any chance to even. I was trying to be considered a main carer for her. I told numerous times I would give up studies. I was prepared to give up my life. I presented sort of like a plan how to look after my sister. There's so many court hearings and appeals, and so many things were presented against me, my ambition to study, my social life, my emotional attachment to my mother, everything was put against me, and, you know, I'm so deeply concerned that my sister was taken away from my family, and we've been just torn apart. I'm not sure if the social services realise how much has impacted all of us. I just wanted to say that I really want to make sure that cases like this are heard, and I'm not the only one whose family has been torn apart. I want to make sure that there's a committee that investigates these cases, and, you know, I just want to make sure that families' voices are heard and cases are investigated, and the system has to be changed. They can't be closed courts, because that just limits decisions within the jurisdiction. That's all I just wanted. That's all, sorry.
Thank you so much. So let's have the Commission.
No, we'll do
No.
the next one first.
The next one is similar.
Yeah.
Mr. McNeil. Yes, item number 1. Mr. McNeil is here.
I am Sabine McNeil.
Mrs. McNeil.
And I'm speaking on behalf of Ale Ambrasaite, who could not come last moment.
Oh, I see.
And I am only echoing what Laila has just said. I have been asked to read this text. Me and my daughter, we are Lithuanian citizens. I arrived to UK with working contract in 2008. Since then, I always was in employment. In 2009, I was accused by Kingston upon Thames Social Services of having alcohol problem, and an interim care order was granted for my then 7.5-year-old daughter. Social Services then promised me that if I tackled my alcohol problem, my daughter would return home to my care. I tackled this problem very successfully through therapeutic groups and psychotherapists' help. It should be noted that I have no clinical diagnosis of alcohol addiction, as I never had been hospitalized because of that or anything like that. In 2009, I voluntarily agreed with Children's Services suggestion having behavioral alcohol problem. Following all expert suggestions, the reunification plan with our daughter had to be drawn in February 2010. Unfortunately, because of my daughter's social worker's personal prejudice,
sorry, the German booth complained that several microphones are open, so they can very hardly understand what she's saying.
Including me, those who have open micros, please turn them off.
if the light is off, do you want me to start again? You want me to start again? I cannot give you. I think the committee has the text anyway, so you could have it in writing afterwards, I think. Sadly for us, the implementation of this adoption plan started in March 2010. For March 2010, they were deliberately cancelled. Many of our contacts with our daughter, contacts with the extended family, auntie, grandmother and cousin, sister, who were travelling from Lithuania, were often not arranged. Lithuanian Saturday school was cancelled. My daughter did not get her first Catholic Holy Communion with her class at Catholic school. From June 2010 till March 2011, we had no activity contact. All contacts were held building. I was not allowed anymore to come to my daughter's school events. We were not allowed to speak Lithuanian language. As a result of it, my daughter was brought to long-term foster care in November 2011. The reason for which my daughter was placed in long-term foster care, my alcohol problem, disappeared a few years ago. On 15th June this year, it will be 5 years of my sobriety. Unfortunately, the local authority does not have any reunification plans for us with our daughter. We have contact only once a month for 2 hours. During those contacts, the supervisor does not allow to tell me any word in Lithuanian. My daughter is not allowed to tell how she lives in her foster home. This year, February contact was cancelled because in January contact I told my daughter that she is Lithuanian nationality and that the Lithuanian president and the government know about her and her living in English foster care. My daughter is in the local authority care now for nearly 5 years. She is 12 years old. It is not too late to reunite us in order to enforce my daughter's natural cultural identity, as suggested by the UK Appeal Court Lord Justice Thorpe in February 2012. The UK Children's Service should support my daughter's gradual return to my care, as it is my child's interest to live in her own family. Furthermore, from June 2009, I fully cooperate with Children's Services and will continue to do so. Why do UK Children's Services at any cost try to keep my daughter in a strange foster family if she can live with her mum and regain her Lithuanian identity, which was lost while in English care? On September 2013, I submitted a petition, Lithuanian girl held as a hostage in UK long-term care, as a complaint over Kingston upon Thames councils in the UK handling the care proceedings. That seems to be her last statement. I just would like to add that I really can't cope with so many individual cases anymore. That's why I'm point 9 on the agenda for collective petitions.
The Commission, Mrs. Bogert.
First of all, as a mother, I would like to express my sympathy for the suffering of the petitioners. Now, I understand that what those two petitions have in common is that the petitioners expressed their concern about the functioning of the UK Child Welfare Services and the UK local authority. My task here is to assess whether there is a legal basis under EU law for the Commission to intervene. The legal basis which were brought up by the two petitioners orally now in the intervention, which I hadn't seen in writing, were the UK Human Rights Act, which is UK national law, the Rome Statute, which is the International Criminal Court Statute, so that is not EU law either, and the European Convention of Human Rights, which is the Council of Europe Convention. Now, when it comes to possibly applicable EU law, in writing it was submitted that there might be a violation of Article 3 of the Racial Equality Directive and Articles 10, 22, 24 and 33 of the Charter. When it comes to the applicability of the Racial Equality Directive, the Commission would like to stress that acts of a public authority, such as taking a child into long-term care or giving a child free for adoption, are not a service in the sense of the directive. nor do they fall under social protection, because the term social protection under the Racial Equality Directive is to be understood as covering social security and healthcare, but not the functioning of social welfare services. Then, when it comes to the question whether there was discrimination on the basis of racial or ethnic origin, this is apparently also not the case in 2 cases at stake, so from this we can conclude that the Racial Equality Directive does not apply. Why? Because the Racial Equality Directive only applies if there is discrimination on grounds of ethnic or racial origin, not nationality. Then, whereas to the applicability of the Charter of Fundamental Rights, I would like to explain that the Charter only applies to it doesn't apply to every situation of alleged violation of fundamental rights. The Charter of Fundamental Rights, according to its Article 51, only applies when the member states are implementing EU law. So the Commission can only intervene in these kind of cases if it is proven that there is an implementation of union law. When it comes to the question whether in these particular cases the UK Child Welfare Services or the local authorities have implemented EU law, this has to be answered in the negative. This is only an implementation of national UK law. This does not mean, however, that there is a lacuna when it comes to fundamental rights protection in the UK. In such cases, it is for the member state, so the UK, and its judicial authorities to ensure that fundamental rights and human rights are effectively respected and protected. So what the petitioner can do is to seek redress at the national level through the competent authorities or through an ombudsman or through the courts. Then after the exhaustion of domestic remedies, there is a possibility to lodge a complaint with the European Court of Human Rights, as the European Convention of Human Rights does not have this precondition of applicability of EU law, but the Charter has, as I just explained. Then, in general, regarding the functioning of child welfare services and child protection services in the different member states, the Commission is currently drafting guidelines to support the member states in strengthening and improving their child protection systems. The objective of these guidelines is to find ways to promote and support an integrated approach and facilitate cooperation and coordination among all agencies involved in child protection issues. These guidelines are expected to be adopted by autumn 2014. And in parallel to the preparation of these guidelines, the Fundamental Rights Agency of the EU is also carrying out a mapping of child protection systems in the different member states. This mapping should be completed by June 2014. But as there is no legal basis under EU law in these cases, the Commission, apart from issuing these guidelines, cannot further intervene.
Thank you. That was clearer than before, but there's something we can do next. Mr. Zaleski, please.
President, first of all, be that local court wherever, in Italy, Poland, Sweden, or Old Bailey, the renowned court, one thing is basic. The language discrimination is totally outrageous. The mother, the father, schizophrenic, alcoholic, minister or MEP of this parliament must have a right to speak to his or her child in his or her own language. Now I am saying as psychologist. I am professor in psychology and have some experience in this matter. Second thing, I see the powerlessness of Commission in these cases, because what do we have to do with the courts? But one thing we probably act. When I hear from the first case, the social worker dares to say to your mother that your mother will not love you. On what basis? Who is this social worker? Something stupid. This is schizophrenia. More than the mother. So, and then the other thing which is crucial in European Union, maybe Commission can do something, because what I hear, that these, or somebody, maybe I missed it, but it was said that the judge will not act against social service, and I think that there is something into it. Both.
I have evidence. Yeah.
Let me say, both judges and social workers are institutions within a country. Surely they will support each other. So the petitioner is weaker, And I think that here a commission should do something about it, at least make them aware of the fact who is the power. They cannot influence, but if we don't do anything, it will go like this. The another thing is, I think very dangerous, this labeling. Who is who or who was alcoholics or whatever, a thief. I remember a very good study in America, so run by good psychologists, department in particular in Texas. What appeared that the judges in America, where law is law, after all, beyond or overall, they tend to label the Chicanos, those who escaped from Mexico to the United States, the parents most in these kind of cases. They are more often they are psychologically deranged or something, that they are sick, than the white ones. So there is something like racial attitudes, be that England, be that Germany, be that whatever, Malta. Can we do some commission? Can we do some basic propaganda, but something positive, to make people aware what is the institution and what is the child, what is the mother, and so on? Because there are some they are not meeting. Everybody goes by his own line. Who is more power, he decides. And the welfare of child is completely lost. This is my attitude. Thank you very much.
Thank you very much. Mrs. Danoka, please.
Yes, thank you, Chair. Just to be brief, I am very happy that today we are hearing these cases, which are, I guess, very, very urgent, and we see very similar approach used by UK authorities, which is breaking the independence of judicial and authorities, executional power, and that's the main problem. If we will see further in the Dutch case, we are looking today for this petition the second time, the same we see in another member state. So that's what we have to care, and that's a breach of European law, independence of different branches of power, of judicial power and then the executive power. And here, Commission as a legislator, I guess, is failing on interpretation of existing European law, not speaking about amending it. We discussed this non-discrimination directive to have, as legislator, a horizontal directive covering more cases and covering more scope of application, but we are still here without it. But still we have this racial equality directive, which, by my opinion, I'm not a lawyer, I'm a mathematician, but the Commission is interpreting too narrow. Speaking about this child social aspects, we know that racial equality directive is covering social aspects, and not saying that it doesn't cover just child protection. I guess it is too narrow approach. And further, of course, you have to, using these particular cases, using this opportunity to see into what is the failure of European law, to come with new proposals to this amendment of equality, racial equality directive, or to table and to push over this horizontal directive. Thank you.
Thank you, Mrs. Danoga. Mr. Landsbergis, please.
Thank you, Madam. I want to say some words on the case of Mrs. Amprosaite, but also is the case about her daughter as well. She is also a human being. The case arises both questions: how to base so long-standing punishment of a child, and it is about European formalism in such a sensitive issues, formalism and growing anti-Europeanism in so many countries. Despite the rights of children, too often are separated practically and legally from human rights, thus even downgraded, I want to raise the question from the very child's human rights side. Mother was punished painfully after being stated guilty due to her dependency on alcohol. When her girl was taken away by UK authorities and put under foster care into a new environment, becoming alienated culturally and emotionally from previous natural for her environment. It cannot be a life sentence, neither to mother nor for child. The times passed, and there are no more indications that Mrs. Ambrosaitis stays an alcohol user. There are medical evidences to prove it, and it can be made if needed. When the court, probably dictated by almighty social work structures, I would not suspect that some persons they could be interested or have a material interest to give child for those families or couples who don't have children. It would be a crime, of course. But this almighty power of social work and workers, concrete workers, dictating the courts is something unbelievable. So when the court decides to ignore the situation when mother is not anymore alcohol user, and it was promised for her at the beginning, both mother and child stay punished without any end. So when the child is not permitted to join her mother, even to speak in a native language, and to join her mother sufficiently long time cleaned from suspicion about the use of alcohol, from where and on what human basis goes this unbased anymore punishment of child forcibly separated from her mother as well as from cultural and religious environment? Why the child is guilty? It is out of any reasons. It is a bedlam. Excuse me. Thank you.
Not only guilty, but also in danger. Mrs. Gantz, please.
I wanted to say something earlier to the earlier case, saying mainly that for me it was unacceptable, the style of the intervention of the representative of the Commission, asking whether we are asking her to go directly to intervene personally. I don't think so, but I think what is clearly the responsibility of the Commission, if there are similar cases like we are listening to these cases today, they have to come up with systematic type of proposals and changes, and if necessary also laws. And in this case it's absolutely clear that we are protecting every day the free movement in Europe. And all of the related issues like the recognition of qualification, the posting of workers, the intercorporate transfer issues, and we can go on and on with these issues. And we are quite negligent with these family cases, which are closely connected with the free movement issues. They are these cross-border custody cases, also what we are speaking here about, these are migrant workers who live in another country having problems with their children. And I am absolutely sure that it is the responsibility of the Commission to come up with some proposals also in this field, which are regulating this type of cross-border cases, really serving the best interest of the child. And I think we have to discuss in that we are also having a certain responsibility to organize a hearing around this issue in the Parliament, to have a oral question with debate, also with a resolution in the plenary. We cannot do it in this, during this mandate, but later on. Somehow clearly asking for some regulation in this field, because what these cases are about is clearly not about the best interest of the child.
Thank you, Mrs. Gons. Mrs. Wertmann.
Yeah, many things. I apologize first of all that I was late, but that's the way it is in this house, that we have 3 meetings at the same time. Concerning the language problem, why can't a child speak in his or her native language? It's also the language of the mother. We have the right, and this must be executed, this right. It's a right of the child to speak in the native language with the mother. And concerning this case where the child was forbidden to talk about how the child was living in this foster home, it's a freedom of speech. How can we forbid a child to say whatever he or she thinks? Who has this right to forbid the freedom of speech or to take away the freedom of speech of a child? I was yesterday in London at an event, and there I learned that a no of a child is actually not a no. It means yes to adults. It's very tragic in this one particular case. But also here, I want to say we must respect the children. We must respect them. It is a respect of a child. The child wants to share the experience with the mom. Where is the problem? It's just a question to social workers, to everyone. A child who has been put in foster care when the mother is a severe alcoholic, I do understand, whereas I have to say I do not know the specific details of this case. But once the mother solved the problem and is willing actually to be in therapy, to be accompanied by therapy, why is the child any longer taken away or held back from the mother? Why? It is the right of a child to be with the mom. It is a right. Where do we have a problem here? And here I come to the Commission. It is a human right to have family. I personally consider the right to have contact with the mother as a human right of every child in Europe. No matter whether an Austrian child lives in Great Britain, no matter whether a Lithuanian child lives in Germany, there shouldn't be any difference. It is a human right that these children have to live with their mom. So here the Commission should come definitely in. What I would like to suggest to these cases is that yesterday at this event that I had a chance to attend and the honor to attend, I learned that the mayor of London and the deputy mayor of London are actually very, in German we say engagiert, very enthusiastic, very committed people. I would like to suggest, without having talked to them before I suggest this, but I dare say that they will welcome this, that you write a letter to them, if you haven't done so yet. You alert these cases to them, or we as a committee can do so. Because I feel our intervention with the mayor or the deputy mayor will probably at least alert them and will probably give them the chance to talk to the necessary services. Thank you.
Yet it's the Commission that has to do the most, the best. Mr. Wieland.
Ja, vielen Dank, Frau Vorsitzende.
Yes, thank you very much, Chair. Just because I would say that I can fully agree with all previous speakers, I'd just like to point to the fact that I think a parliamentary committee isn't a talk show. So this is not always usual to have these opinions. We need to remain neutral, but these cases are very difficult, of course. But two things are important. As Madam Weitzman just said, of course, there are lots of reasons here underpinning this, and we shouldn't forget about the rights of the parents. But we're not talking about the rights of the parents, we're talking about the rights of the child. It's the rights of the child that are important here. And I've seen similar cases, and I would say that if there is a justified reason for contact with the child, perhaps if you should remove the child perhaps from one parent, or if it is comparable to abduction, there could be reasons where authority says we think that we should speak in a language that the environment that's accompanying the parties understand. But that has to be in a justified case. It can't be that you simply said, I don't understand what you're saying if you're speaking to your child, so you can't speak Lithuanian, Latvian, or German, or Afrikaans, or whatever it may be. I would say that explicitly. Now, secondly, there's also a point that's very important to me, and I think we'll come back to what the petitioner has said. When the right of the child prevails, then there are cases, and this is something we do see due to regulation. There was a child that was taken to Africa, and it was a long case, lasted a long time, and after a whole chain, I think it was 8 years it took, and the federal court said that this was all illegal, against the law, but now it's reached a time where it's no longer in the interest of the child to take the child from Africa and bring them back to Europe. So that's the de facto situation. Now, it's when we have this field, and a long-winded law is bad law. That's what we should be aware of. The Commission should also be aware of that. National government should be aware of this, but also authorities should be aware of this. Now, we're talking about the right of the child. Therefore, we're not always looking at the right of the petitioner. It's not the child that requests a petition, it's often the parents. And if the child can't put forward their own petition, then we've got to think about the child, not necessarily the father, the mother, or the parents. Sometimes it's the parents, but it's always the authorities that need to stand on the side of the child. And every wasted day is a loss of rights for the child in question. The authorities need to react quickly, therefore. They need to always act in the interest of the child. That's not always the case. Sometimes the end result is what one of the parents wants, of course. But there's always two sides of the story. There are thousands of cases, of course, where the authorities are acting in the rights of the child. But we need to make sure that we work on this more effectively.
Thank you. I would like the Commission to broaden its legal arsenal. Mrs. McNeil, would you please continue?
I must say I'm very, very, very tempted to respond to everything I've heard so far, which was shocking in terms of the Commission, as far as I'm concerned, because we are here with a large delegation of people, and I am speaking on behalf of 1,000 children taken a month in the UK. 90.
Please respect the committee. Do not applaud.
I'm sorry, the F5 button doesn't work. Oh, yes, it does. 100,000 children a month, and 90,000 or 100,000 children a month are too much. When are individual cases too much? When is pain too much? I can assure you I've seen enough individual cases, and there are at least one Belgian journalist who has seen enough individual cases, and there is one journalist, Christopher Booker, who writes regularly about individual cases. But nothing changes, and nothing has changed in the UK. That's why we are here today. We are here crying for help. There are children screaming to be heard. If you don't hear those children scream, who will? Only the United Nations. That has to be our next step. What are you living if you only preach those wonderful laws? It is exactly the gap that Mrs. Janoka has spelled out, the gap between the judiciary and the enforcement. If painting is done, somebody comes and checks whether the paint is done properly. You better check whether the children are kept in their best interest in the social services in the UK. The best interest is they are taken for emotional risk, future emotional risk. And then what happens to them? It is just too much. I can only tell you that. It is a shock therapy that I have gone through over the years. And I'm supposed to convey that in 3 or 5 minutes now. With 32 families sitting there, I have considered one case as the worst one, where the parents are sitting in prison for 7 years. I've visited them in prison. They are amongst 200 who are taken into prison a year. That's what we are facing. John Hemming is the only MP who stands up regularly. What has his activity changed? Nothing. We are here to expect change. Because what's unique in the UK has been mentioned already. Parents are threatened with imprisonment. They are all intimidated. They don't dare to speak out, because if they do, they land up in prison. 200 a year already in 2006. Forced adoption. Ian Josephs is the veteran. He's been watching this case since these problems since the 60s. He still gets 6 to 10 calls a day. He is safe because he's in Monaco. He's beyond UK jurisdiction. He calls it punishment without crime. So I republished his website with exactly that phrase. That's exactly what's happened. What's happening? The children are punished and the parents are punished. I am not so interested in all of these private custody issues either. I'm interested in the systemic, institutional abuse of children and parents, which is an undermining of society. That's what's happening in the UK. And I'm saying that as a German who doesn't have children, who doesn't have grandchildren. But knowing what I know and not to act on it would be against my conscience. These people don't seem to have a conscience. That's what's happening. That's what we are up against. And I thank you for the sympathy with the mother, but I want you to act on your conscience and with your feelings, please. I happen to be half Slavic. The censorship of contacts is the most cruel thing. That's what's happening to children. We've got with us the Portuguese family whose 5 children have been taken. They can't be speaking in Portuguese. It is too much to describe each and all of the problems. That's what I'm telling you. So I had to see. I am a system analyst. I try to find the patterns that connect. I'm here with people from Wales. They have seen it more closely than we can in London. It is too much to believe. I don't blame you if you, as the committee, can't take it either and don't believe it. It is too unbelievable what is going on. You cannot imagine that that's happening in a Western country, the UK with its wonderful image.
Thank you so much. We are not that unaware of it. But there is this legal gap that we are dealing with, and we have to complete it.
It's a big gap, I'm afraid.
And this is a destruction of the European idea. I completely agree with you.
It is absolutely too much.
Thank you so much. Oh, yes. I would like to complete this first circle of...
Does she have any more to say, or is that...
Oh, no, sorry.
Yeah, please. She hasn't finished. She hasn't finished.
I thought I had 5 minutes, and I'm sorry I didn't look at the time. But I would like you to mind the traps between the institutions. We are here in a battle for Britain's children, and that includes all of the children from all of the countries that are in Britain, kept and held by the authorities. We hope for a special investigation. That's our request, and I hope you hear our cries for help. Thank you.
I would like to complete this this first session relating to the United Kingdom by addressing to you a petition submitted by a member of the European Parliament, Mrs. Maria Gabriel, relating to something similar happening between Great Britain and Bulgaria. So I won't read it all of you, but I would like to... It was not possible to have it included in this agenda, but I just read it to you. So let's go to similar...
Back to the Commission.
Oh, no. Yes, Mrs. De Luca would like to say a few words.
From the Commission.
Mrs.
Yes, thank you, Chair. We have heard all these cases relating forced adoption in the UK. I must say that the Commission is fully aware of the problem because we have received several complaints about the rate of domestic adoption in the UK and also carried out without the consent of the parents. And I would like to point out that not only foreigners, but also British people claim to be victims of forced adoption in the UK. Indeed, the complaints which were received directly by the Commission came all from British people, for instance, from grandparents of children who has been put up to adoption without the consent of the mother. Normally a single mother also. Indeed, there was already a study of the European Parliament dated from 2009, which identified the high rate of domestic adoption in the UK compared to the other member states. And a majority of these adoptions are carried out without the consent of the birth parents. So the problem is well known. What the Commission can do, not much, because you know that the issue of adoption is not currently regulated at the EU level. International adoption is regulated by an international convention, the 1993 Hague Convention on Inter-Country Adoption, of which all member states are party, while domestic adoption, national adoption, are in the remit of the member states. So it means that member states can regulate as they want the issue of adoption. The Commission until now has suggested to these parents to exploit all possible remedies at national level and in the last instance to address the European Court of Human Rights because for the breach of the respect of family life. What I can maybe the Commission as guardian of the treaty cannot do much more in this situation, and I want to inform you that a possible legislation at the EU level on adoption can only address cross-border cases. So cases like this one related to forced adoption in the UK would not be
in the scope of this possible regulation. And in any case, as it is regards family law, we would need the unanimity of all member states to have a EU regulation on adoption, which is not the case, I can assure you. Only things that I may suggest to this committee, because we have cases like the Danish cases, the cases of the Jugendamt in Germany, where this committee organized a fact-finding mission in order to really understand why the situation is like this. Maybe this could be a solution, a fact-finding mission of this committee. But from the part of the Commission, I'm afraid that we can do much more on this issue. Thank you.
Doesn't sound very optimistic, but Mr. Kazbetia had already asked the question, and that will...
Gracias, Presidenta.
Thank you, Madam Chair. First of all, I would like to express my solidarity with the petitioners. These are real cases of very deep human drama. And when I was hearing the explanation of the facts and events, I noted that I felt like I was going 150 years back into the Victorian era and reading a text that was written at the time concerning the prejudices and the archaism of the shown in the authorities, in the decisions made by the British authorities. I wasn't surprised, because it's usual that in these human rights issues, the Commission acts like Pontius Pilate, washing its hands and saying that it's not its fault. I read the text written by the Commission, and I read what it says, that based on the information provided, it does not seem to be that the European Union law is applicable. Therefore, the competence only belongs to the member states, since there is no violation of the Treaty of Fundamental Rights. This seems like a hypocritical attitude by the Commission, and hypocritical because these cases arouse quite much attention in their countries, but the Commission seems incapable of keeping the member states in line so that they comply with human rights. This is not the only country where situations like this have arisen, and the Commission seems to be looking in another direction, and its answer is constantly that this is an issue that is under the competency of the member states and their authorities. I think that the Commission should be the guardian of all fundamental rights, whether their case is under its competency or not, because it's the ultimate guardian of the values of the European Union. It's the ultimate guarantor of the fundamental rights of the citizens of the European Union. And in this case, it's acting with hypocrisy and washing its hands like Pontius Pilate. And I have to denounce that here. Also, I would like to support the petition by our colleague Verma. And since I've seen the seriousness of the case and the recent cases that have been outlined here, I think that we need to send an investigative mission to Great Britain to find what can be done there, to find what our options are. I think this is the proper step that this committee should take. And although it will be done by the next legislature.
Thank you. Yes, Mr. Bolsonaro.
Madam Chair, very briefly, because it's not only unacceptable, it's just fundamental to be condemned by our Peti committee. I would like very much to suggest the idea first, yes, a fact-finding visit to UK, but when putting together UK and Jugendamt and Denmark, I think that the next Parliament should organize a public hearing about the state of play with those absolutely unacceptable cases, and I really hope that a successor of Madam Reding will come up to that hearing to tell us about the rule of law, because here is just about the rule of law. When the parents are depossessed brutally by their kids without their consent, this is not about human rights. This is not about European values. It's I refrain myself to say a tougher sentence, but it's not draconian or any kind of other draconian regimes we experience all along the history. And after such a public hearing with the Commissioner, we shall probably consider the possibility to launch the idea of an European citizens' initiative to stop, to ban the abusive way of taking away the kids from their families, parents without consent, because we can simply not accept the fait accompli done by member states which behave in that way. It's just unacceptable. We have to stop it, and this will be one of the most painful legacies for the next committee. Thank you.
Mrs. Wertmann, I would not give you the floor now. Please, I know what you're going to say, but Mr. Mayor would like to intervene. We are out of time, you know. Mr. Mayor.
Muchas gracias, Presidenta. No.
Thank you, Madam Chair. I will be very brief. I agree with the proposals made by our colleagues. The petitioner has made a statement that I believe, from the humanitarian point of view, is flawless. And I think it's necessary for this Parliament to initiate an investigation into the circumstances in the United Kingdom. Not during this legislature, of course, but I think that in the next legislature we need to commit ourselves to send a delegation that will investigate these cases. Also, I support Mr. Bostinaru's proposal to have a hearing to deal with all of the cases so that the European Union may legislate once and for all and avoid these legal quagmires that cause unnecessary pain and human suffering. So I second Mr. Bostinaru's proposal, and I agreed that we should send a delegation.
And take into account that this committee is going to be a new committee after a few months. The present committee will write to the United Kingdom government. The present committee will address the local authorities, as already pointed out here, Merton and anywhere else. The present committee will contact Mrs. Reding as present commissioner, and I suggest that the subject should be discussed in an extent by the present coordinators of this committee, and plan what is going to be done immediately, pressing the Commission to do something or addressing the newcomers to keep on working on this issue. So I think you agree with it. Thanks for your interventions. And we now go not to similar issues on the Netherlands, but in France. So we come back to the Netherlands after it. So item 13 by Mrs. Christina Oros. All right, Mrs. Christina Oros.
Yes, I'm here.
Okay.
Thank you very much. Dear Madam Chair, representative of the European Commission, and dear members of the Parliament, I am Christina Oros. I am Hungarian, a mother. My life and that of my daughter are in a hellish limbo because of a protective international law turned upside down. With primary custody of my child secured after my divorce, I felt protected. I thought I was crossing my toughest hurdle when I legally fled with my child from France to my home country of Hungary for her safety. But I faced child abduction lawsuit brought by the father and governed by the Convention on Civil Aspects of International Child Abduction. My daughter was returned by police forces against her will, bound in an ambulance during 20 hours, then placed in a foster home for more than 1 year. I was waiting for my extradition twice. The last time I spent 41 days in jail. In Hungary, I was declared guilty of child abduction and sentenced for 1 year in prison, suspended for 2 years, just as in France, where I was sentenced at first instance for 1 year in jail. My daughter hasn't seen me and hasn't had any contact with me in 3 years. How could this happen? Here's where it gets sadly familiar to many of us, regardless of nationality. I wasn't and I'm not a kidnapper. I sought to shelter my daughter from an abusive father, and taking her to our home country seemed the best solution. I had the law backing me, but the law betrayed me. Today I seek to spread awareness and get in contact with victims of misuse of the Hague Convention, which is having paradoxical effect. The more reported cases there are, the more we can change the legal system. Today I try to make people aware of how fundamental rights of children and mothers are abused. I fight for my daughter and for other abused children and battered mothers involved in international cases. The Hague Convention on Civil Aspects of International Child Abduction was initially created in the 80s with the intent to protect children from the harm of abduction, as well as protecting custodial parents from having the other parent unlawfully remove or retain the child in another country. The Hague Abduction Convention doesn't distinguish between primary carer parents and parents who have parental responsibility but are not main carers. Thus, a child abducted by a primary carer mother to one country is just as likely to be returned as is a child taken by a father with parental responsibility but who only enjoys contact with the child. From my point of view, more emphasis needs to be placed on children's well-being and best interest. Often child abduction litigation for the immediate return of the child can be quick, but also exceptionally harsh and brutal, dealing with technical defenses rather than the best interest of the child, and often where the children are stuck against the abducting parent, invariably the primary residential parent. The return of the child should be also refused if not permitted by the fundamental principles of the requested state relating to the protection of human rights and fundamental freedoms, and requires the respondent to demonstrate by clear and convincing evidence that the return of the child would violate fundamental principle of human rights. Spanish court refused a return on the basis of violating human rights and freedoms, where it determined a fleeing mother would be deprived of a due process in the courts of the child's habitual residence. Also, 2 Australian courts have endorsed the defense in dicta. But today, the convention is often used against mothers who are the primary custodian of their children. The drafter of the Hague Convention assumed that the international child abduction almost always harms the children. In my opinion, one of these situations in which abduction may be unbalanced beneficial is when a primary caretaker removes the child from a home filled with domestic violence. Today, many so-called abductions in which Hague intervenes occur when mothers attempt to escape family violence with their children in tow. In other cases, serious and credible child abuse allegations are made against the parent the victim tried to leave, but the court in the abducted nation returns the child anyway to their abusive parents. Even so, the primary custodian cannot safely return with the child or place them into foster home. They do this with the belief that the foster care in the child's place of habitual residence is an appropriate placement until the allegations are resolved. In cases where mothers cross international borders with their children to escape abuse or other domestic violence, they are treated as criminals, they are prosecuted and risk prison. They are not seen and recognized as women seeking for safety for their children in their own lives. The convention relating to parental abduction often fails to properly address the situation of parents who flee to protect themselves or their children from abuse. In some instances, moreover, the law may increase the risk to those who have been abused. The Convention makes almost every domestic violence victim who goes abroad with her child subject to the remedy of return. While a petitioner has to establish a prima facie case under the Convention to obtain relief, the two most important requirements that the child be wrongfully removed from its habitual residence are easily satisfied. Common sense might dictate that a victim who removes her child from a country in order to escape domestic violence has not engaged in a wrongful removal, or that a mother who removes her child from a place where the mother has been forced to live under penalty of death by her child's father has not removed the child from the child's habitual residence. But the case law of the Hague Convention sometimes lack common sense, in my opinion. The Convention framework works well for those abduction it was designed to address: abduction by parents seeking to gain litigation advantages, or abduction by non-custodial parents attempting to circumvent custody orders. In this situation, the abductors asked for selfish reason, and most children probably will be harmed by the abduction. The Convention, however, operates to the detriment of children when its remedy of return can be invoked by a father who has abused the child or the child's mother and caused her to flee for safety. In this common scenario, the remedy of return jeopardizes the children's and mother's safety and the children's well-being. Reforming the Hague Convention on child abduction is an important task. The objective of the European Union is to create consistency of laws, regulations, standards and practice of member states, and certainly must be a challenge to harmonise family law. Also, Switzerland is not a member of the European Union. Its relationship with the member states remains paramount importance. In 2007, Switzerland took decisive action to protect children who were being harmed by the application of the Hague Convention, and its parliament passed the Federal Act on International Child Abduction and the Hague Convention on the Protection of Children and Adults, called Swiss Act, entered into force in 2009, giving important and necessary guidance to Swiss courts about the phrase intolerable situation in Article 13 of the Convention. The Swiss Act also directs courts to appoint representatives for children in Hague child abduction proceedings. Contracting states of the Convention should follow Switzerland's example and adopt similar reforms. Reformers in Switzerland became concerned about the application of the Hague Abduction Convention in these defences in particular after they observed the child custody case of Russell Wood and Maya Wood, known as the Wood case. Switzerland proposed to the international community that a new provision be added to the convention that should supplement Article 13b. After the fifth meeting of the Special Commission to review the operation of the Hague Convention had in 2006, the Swiss delegation introduced a working document entitled Return and Best Interest of Children, would allow a court to refuse...
Conclude, because...
Yes. The court to refuse to return the child if the following criteria were met. The placement with the applicant is not manifestly in the best interest of the child. The abducting parent cannot care for the child in the child's habitual residence or cannot reasonably to do so. And the placement in foster care is not manifestly in the best interest of the child. Unfortunately, this proposal was rejected. Two more phrases. The Swiss demonstrated that the Hague Convention defences are interpreted too narrowly in various scenarios, resulting in harsh outcomes for the children involved. These scenarios typically involve abduction by primary caretakers. The Swiss legislation is also admirable because it directs courts to appoint counsel for children when their parents are parties to a Hague Convention proceeding. Switzerland's automatic rule has the advantage of eliminating parents' and courts' discretion on this issue, a discretion that has caused inequities in the protection of children's interest. The Hague Convention, which was meant to... Yes.
People will not be permitted to present their own cases. That's important. We have only less than 1 hour and a half.
Okay, so court in the European Union would be well served to consider the Swiss legislation that seeks to improve the application of the Hague Abduction Convention by defining intolerable situation and requiring the appointment of counsel for children. Thank you very much.
But now the Commission, please, Mrs. Villar-Badia. Please be quick.
Yes, thank you, Madam Chair, and thank you to the petitioner for this thorough presentation. Well, first of all, let me say that we are very sorry about all the difficulties that you've gone through in your abduction processes and in the current situation in which your child is in France. Sorry. Yeah, sorry. So, well, we understand the frustration of many parents here that have been presenting their cases, and let me assure you that the Commission would be very happy to be able to have more powerful instruments to be able to act against what is perceived as injustice in situations in many cases. Unfortunately, the Commission can only do what it can do, which is basically to ensure that what is already in force now is properly applied. And sometimes, unfortunately, what we would all desire to have already as existing law is still not existent. And that is because, as one of my colleagues said, sometimes member states do not have similar positions and cannot reach consensuated decisions as to what legislation to want to adopt in this very sensitive issue of family law, where each member state has its own social, cultural, traditional, religious background and beliefs. So it's not to justify the Commission, but to explain you that we often are confronted with situations in which we feel frustrated because we cannot do more. And indeed, our job is to propose new legislation, and we do as much as we can. Of course, sometimes we do not propose legislation if we see that it's going to end nowhere. And as my colleague also said, for the time being, for example, it's just an example in the field of adoption, we know there would be no consensus in adopting common laws on adoption, so there is no point for the Commission wasting time of MEPs and of its own resources in putting forward legislation that will never make it at Council level. Well, all this having been said, we understand that in the case that has just been presented, there was indeed a decision by Hungarian courts stating that there had been a case of abduction. Now, this obviously is based on the current Hague provisions as they stand, which the petitioner doesn't believe are fair or logical or reasonable in all situations. Unfortunately, the Commission is not the body to judge whether the Hague Convention provisions are adequate. The Commission can only ensure that its own regulation, the Brussels II regulation, which complements a convention which has been adopted by member states at international level, is applied correctly. So it is good to hear the views of citizens and petitioners, but unfortunately there's so much that we can do anyway. So there was, on the basis of current provisions in the Hague Convention, 3 levels, if I understand correctly, of Hungarian courts considered, having heard the petitioner, that there was a case of abduction. Subsequently, the European Court of Human Rights in Strasbourg considered that, in fact, the return of the child back to France was done in too long a time, so that there were unjustified delays. And so it seems that both the Hungarian courts and the European Court of Human Rights did not question the fact that there may have been an abduction. The Commission cannot substitute itself for the national courts, whether it's Hungarian or any other national courts, and we cannot judge specific cases and say in this case that there's been violence, if that can be proved, this cannot be considered abduction. I mean, we have no power to do that. So national courts, which within even one same member state may have different opinions, in these three instances, district, regional and Supreme Court in Hungary, it was considered that there was a case of abduction under the Hague Convention as it currently stands. So we unfortunately cannot do much about it. This case it didn't come down to the Brussels IIa regulation. It didn't need to be applied in the case of the abduction. Now we are very sorry to hear that you're having trouble in seeing your child, which is...
Could you please come with a suggestion rather than... sorry, I'm so sorry. You have explained our disabilities very well, but solutions we need, not excuses.
Yes, we understand your frustration, but please try to understand who is the Commission. No, I understand, but I mean, the Hague Convention is an international instrument adopted by member states.
Let's try to do how we can deal with the Commission, the Council and the European Parliament.
Right.
The excuses we can all give. Okay? Thank you so much.
Okay.
Mrs. Gons.
I'm not trying to give excuses.
No, it's not personal.
No.
Please do not accept it as such.
No, I don't take it personally.
Mrs. Gons.
I'm just trying to say that
Mrs. Gons.
Yes, I know that's a very emotional session today, and it is absolutely clear how human beings, parents and children, got lost in this whole labyrinth. And in one hand, I accept the excuses from the Commission that they are not the Supreme Court in one hand. The other hand, it is not true that you cannot do anything. I think we could set up training programs for those who are intervening in these cases. On the other hand, we can regulate how long these cases can take place. It is unacceptable that a mother cannot have a contact with her child for 3 years. I think you don't have to intervene on the national level, but I think we have to map the situation all over Europe. It is not just about Great Britain, it is about France, it is about other countries. And I think the Commission should come up with a working programme how to move on with these cases, from mapping, training, international regulation, recommendations and so on. And it is totally missing. You are going into the individual cases and you are saying that we are really sorry we don't have any competence. It is not true. We had competencies in terms of other police trainings, competencies regulating other type of issues, cross-border issues. I'm absolutely sure that the Commission has competence to come up with this type of working plan.
Thank you, Mrs. Gons. Mr. Zaleski.
President, one more time in short. I think that the numbers start to speak for themselves, and I mean the children, number of children, and they have the association that, not comparing, but having in mind our concerns about the energy issues in Europe, Ukraine, Putin. I think that the issue of children, mostly intercultural parents, must be more salient in Europe. It must be spoken, must be vivid. And I think that the duty of our Commission and this Parliament, of which I am a member, for the next legislature is something to do on the global level. Not just single cases, but there are thousands of them and there will be more and more. Most often it is so that the right in these court cases is stronger on the host parent. And of these more often this is the father from Western countries. This is what the statistics say. So the action in this regard is really more than needed. The higher economic, that's my argument, status of these countries, I mean Western comparison to the Eastern, does not go hand in hand with better child welfare, and we have to understand this psychologically, than in the poorer countries that are represented more often by the Eastern European countries. We have to be aware of it. If it's not the issue undertaken by the Commission in the sort of global policy, so there will be a single case in this harbour, elsewhere in Marsilia, and then the cases are lost. There has to be some more global policy elaborated, and during the next 5 years status, I think it can be more more often spoken, done something, and this is the duty of our Commission. Thank you very much.
Thank you. Mrs. Wertmann.
Thanks. I'm once more shocked that we cannot stand up as the European Commission for the human rights of the child, because if the child and or the mother are being abused, I think we have a human rights here. We have to protect the child and the mother. If the mother's most important duty in her life, in her biological life, to protect the child from an legally abusive father is neglected, I think we should not even sit here anymore. We are by no means judges, we are by no means courts, but one thing has to be clear. We, as well as the esteemed Commission, have to respect and have to stand up for the human rights, for the women's rights, and most important, for the children's rights. And this is part of the children's rights. Child's rights, that we actually respect the child's right and rights to have a childhood without the violent experience or any violent experience. If we must do it, it's our, and in that respect, I think we should continue. And yes, of course, court cases last way too long. I don't see any reason why we should support the long duration. I'd rather see some regulation here that certain court cases cannot last longer than this or that period of time. Whereas I have to say, I know the Hague Convention very well, and I must say the Hague Convention has actually described it very well, the duration of time. Thank you.
Briefly, Madam Chair. Colleagues, do you remember recently we have discussed about Drosophila melanogaster? And we've been told by the European Commission, yes, there are rules how this little insect can cross the borders, what are the obstacles, what are the checks in the airports, and so on and so forth. Drosophila melanogaster, it is a part of the EU rules and regulations, but the kids are not. We are told now again and again by the European Commission, okay, it's nice, it's dramatic, it's painful, do exist, but yet we have no powers. I see no will and wish from the Commission side, at least, to build up guidelines for the behavior of the member states, our member states, when involving EU citizens belonging to different member states, when involving kids with one parent with one citizenship, another with another citizenship. How to address at least this issue. No idea to start working on that. No idea of collecting opinion and information from member states what to do, because it's so easy and so convenient to say, sorry, we can do nothing. But to see, yes, we can do something, A, B, N elements, because the Parliament, I'm sure, the Parliament will be willing to work with the Commission to regulate on the problem of the children, as in the case of Drosophila melanogaster. The comparison is maybe not fair, but this shows the huge gap in perception and in action from the European Commission side. We can design the carrots, we can design everything else, but not such a dramatic problem which involves human beings. And this is unacceptable. European Commission, you cannot continue in this way to say, sorry, our hands are locked, we can do nothing. Please start doing something and the Parliament will be on your side. But stop complaining about your powerless, because if your power is indeed insufficient or is not existing, it's better to build up another system, because now in May, the European citizens in our member states, including the mother and the father, which are depossessed, will question us, you the MEP, what you can do for my tragedy. And I will tell, sorry, the European Union is beautiful, it's a masterpiece, but when it's about your kid, which was taken away by abusive discretionary authorities, we do nothing. If it's so, we have to change the rules for the European Commission. Stop. Thank you.
I would remind also that we have an internal market with a free movement of cultural goods, a special directive, and there is a problem with adoption and these difficulties. Would you like to speak now, Mr. Jan? Okay.
Chair, I think the basic comments are something that I make. And also Victor De Solero, I think I'd just like to put that on a more positive note. We need to recognise on the other side of the coin we've got the different rights here, and it's the member states, of course, that have their own competence there, and they defend their own legal measures. Now they feel attacked and they say, well, of course that's not the case under Brussels too. But I'd like to call on the Commission that we all know that there are problems. They've got allies here. We've been to Denmark, Spain, Germany. We've been on fact-finding missions, and we've always got the debate there where member states say that that's our own competence, that's our responsibility. Thank you for coming, MEPs, they say. But for this issue, we are responsible. They try to do that with all different types of measures. There's a lot of resistance, and so I say to the Commission that we're allies. We're trying to defend the rights of the child here in Europe. We're trying to establish the right basis. And the second problem, and I think here, if we've got the rights of the child, it's difficult when there are divorces, separations, and the parents argue about the children. And what I do recommend, I've already recommended one thing to the previous speaker, but I think we're going to have to look at this in the next legislature. We're going to have to discuss that with the Commission and with Member States. We're going to see how we can improve the fate of children in Europe. But second, we also need an advisor for the parents that are affected. I'm not a lawyer, as I said, but we do know that this is a very painful story for many different people. We've seen that on our fact-finding missions. And if we look at the Hague Convention, we're talking about different points from the perspective of the child. And if you've lived in one country for 10 years, say, that they've been born and raised there, then the child's perspective, their focal point is that country. And then if there's a separation, there's always an argument, and then it's often the one partner who goes back to their home country. And we have to be clear that if they do that, then their legal position has worsened considerably. We'd have to let them know. That's what the advisor needs to tell them. For instance, if you've lived for 10 years of your marriage in one country and then you leave, that's perhaps often the first mistake that you can make. And you could say that I'm justified for whatever reason. I'm going to pick up my child. Perhaps the other partner comes, or whichever partner it is that you're accused of abduction. And then we could see the need for an advisor that would stop these situations, because there's different countries involved. One person's in the country, the other that isn't, and there are different issues there. So I think that's just my general comment, and I'll try to stick within the time limit, but these are very, very emotional cases, and together with the Commission we need to work on this. We shouldn't see ourselves working against one another, but we need to act together in order to get better regulation.
Thank you, Mr. Jan. We'll go straight. I will give you the floor after completion relating to children, Mrs. Badia. Now we go to item 12. Relating to the Netherlands. Mrs. Antonova.
Mr. Antonovs
is present, is she?
Yes, right here.
Yeah.
Oh, so Antonov.
Antonovs.
No,
right.
sorry.
No problem. Can I?
Yeah.
Please do.
So the European Commission says they cannot request from Dutch government that they release my brother and sister because, I quote, it is for member states alone to ensure that their obligations regarding fundamental rights as resulting from international agreements and from their internal legislation are respected. Therefore, the Commission is not in position to comment on the fundamental rights issues raised by the petitioner. This shows that the European Commission has double standards. When Ms. Tymoshenko was imprisoned, the whole EP and the European Commission demanded from the current Ukrainian President, Mr. Viktor Yanukovych, to unconditionally release her. My brother and sister were taken hostage and stripped from all of their human rights because the language that was spoken at home was Russian. Also, from the day one of hostage taking, my brother and sister were forbidden to speak with each other in Russian, with only goal to force the children to forget their roots, which is severe violations of basic human rights. This is a clear form of fascism. My mother won a court of appeals twice, and the ruling was simple: immediate return of the children to their mother. The workers of commercial social services company Salvation Army gave the judges the finger and went back to the lower rank corrupt family judge and arranged a new urgent permission of removal of the children within minutes after without a prior hearing. When we made an official complaint against the family of judge who gave the new permission for removal of my brother and sister after we won the High Court. In written response to complaint, she, probably blinded by her own arrogance, responded telling us that she considered that the High Court didn't do their job correctly by ruling in my mother's favor. So this lousy, low-rank child judge decided to be Supreme Court judge for a day. This is a severe form of power abuse, and no one in the Netherlands wants to do anything about it. It is extremely hypocrite that you can demand from a country which isn't even a member of the EU to release a prisoner, but somehow you cannot request a member state to stop this 2-year-long marathon of human rights violations and reunite the family. While you will be soon heading off to your comfortable homes, my brother and sister will going to be stuck at the hellhole that is the living facility where they are held and where they are not even allowed to eat whenever they want. I'm extremely disappointed in the European Commission. This shows clearly that issues like the maximum voltage of light bulbs is more important than lives of innocent children and their families.
We have a video now.
We may watch a video now relating to this item, please.
Er wordt niet gefilmd, meneer.
Wat hier aan...
Er wordt niet gefilmd, meneer.
Wacht even. Ik moet een bepaalde bewijs van massa hebben.
Ik wil naar mama!
Pardon? Ja, maar dit is ongelooflijk. Jullie hebben tot nu toe ook eigenlijk amper wat gedaan. We hebben aangifte gedaan tegen de ex-man die de kinderen mishandeld heeft. En jeugdzorg doet er alleen maar alles aan om de kinderen met hem te krijgen tegen hun zin. Maar het is ongelooflijk. Kijk wat er nu gebeurt. After
video, please.
After this, I recorded this video. This was happening when my brother and sister were removed. Immediately after this video, there was an international arrest warrant issued against me by the Dutch state, telling that I'm a terrorist and a threat to the state's stability. After a half year of chasing and 3 days in jail, they eventually dropped the charges, and as was later figured out, the prosecutor who gave the international arrest warrant is in very close connections with those for social services. So this was a scare tactic.
The Commission?
Yes, thank you, Mr. Chair. Mrs. Chair, of course, I think we are all equally touched by these very disturbing images, but I can only say I'm very sorry to tell to the petitioner's son that he is so disappointed with the Commission's reaction, because essentially I can only repeat what has been said before. The task is to examine whether there has been a breach of EU law in the case of the petitioner, and here, in cases of child custody, there is no basis in EU law to consider whether the Charter of Fundamental Rights, which prohibits discrimination, would also require that it concerns a case of implementation of EU law, which is not the case here. Granting of custody rights, arrangements for their exercise, and the role of the social and child protection authorities is simply not a question for EU law. And discrimination on the basis of nationality is only prohibited when it falls in the scope of EU law. For these reasons, I can only repeat what the petitioner's son did not like to hear, that the Commission cannot follow up on this. Thank you.
Thank you. It's obvious that we have a gap in legislation that has to be filled the quickest possible. Mrs. Danoga.
Yes, thank you. Chair, continuing your statement. Yeah, I think we do not want to overwhelm this gap in legislation, and there is a breach, by my opinion, just all of a basic principle of the European Union: free movement of people, a free movement of workers. Because we are hearing here cases from citizens of Eastern European countries, Western European countries, who are working, who were in other member states for work, yeah, who are living there as permanent residents. And what, for example, in the cases of Latvian citizen Antonova and Ilja Antonov, of Latvian citizen Laila Brice, we have in Latvian press now the information that it's dangerous to go to another member states for work, because your child can be kidnapped. And that is the breach of, and I repeat what my colleague Kinga Göns told, that we just can to refer to this principle which is breaking. We don't need only to speak on child adoption legislation, but on right for free movement of workers. Because these workers, they have families, they have children, and they are afraid to execute this right. And continuing my second point, I try to be brief, is the behavior of Commission. You see, we see now so many officials representing Commission. You are full-day working officials there, and you do not want even to contact properly the member states. In the case of Antonova, I refer to the case of Antonova because we are seeing, examining this case for second time in 1 year distance. The first examination of that case was in February last year. And during that time, Commission did not manage even properly to ask from member states for proper answer. Only one letter was sent to the Dutch government, and the response was just neglecting the European Union as such, and the Commission and our committee, because the Dutch Minister for Justice just wrote, no, it was not only the reason why children were withdrawn from the family that they speak their mother tongue within the family, but there were another reasons, so there is no breach of international law, it's our interior Dutch matter. And Commission officials, you did not even manage to send another letter to the very same official to say, by saying that your answer is not proper. You please answer us just deeply concerning the case, not like this. Yeah, and we even do not have now in the dossier the proper answer from Dutch authorities by having so long court cases, by having some decisions in favor of mother. No proper answer, and we have now here also a lawyer who is watching the case, but unfortunately Dutch authorities are completely neglecting us, and we smile and we do nothing. That's awful. Yeah, and I want, of course, support the idea to make a fact-finding mission to Britain, because we have a lot of British cases, but this is a matter of all member states. Yes, mostly with migrant workers from Eastern Europe settling in Western Europe. And that's a very dangerous tendency with kidnapping of children. We have to tackle using all instruments we have.
Mrs. Danoga, the Commission, do you have anything to add relating to the items we've been discussing up to now? If you wish to, to intervene, yes.
If I may, you asked to come up with suggestions. Well, we had our Commissioner, Vice President Reding, suggesting to abolish Article 51 of the Charter, which limits the field of application of the Charter only to when EU law is applicable, to have a general basis for the EU to act in the field of fundamental rights. I suggest that we will all lobby to abolish Article 51 of the Charter, so finally the EU can also act in the field of fundamental rights. And we would like the support of the Parliament for that. Thank you.
Yeah, thank you, Madam Chair. Yeah. When I was trying to respond to the petitioner, I meant to say also that, in fact, the Hague Conference has set up a working group to study the relationship between violence cases and abduction, perhaps to tackle situations like the one described by Mrs. Orosz. So that on the one hand, then also we've been accused, although the MEP is not here now, that we don't do anything. Well, we do what we can, and as much as we can. For example, there's this judicial network, European judicial network in civil matters, where member state representatives meet and discuss, for example, abduction cases and custody cases, and where difficulties that arise in particular cases are discussed bilaterally. And one of the topics that we intend, we've discussed this internally, and we would like to see a bit more in depth how we can help in all these matters that involve the social authorities. When access rights are granted to a parent, but the way in these access rights are granted, so that perhaps we can see whether there can be some common approach adopted by member states' authorities as to how these access rights should be granted, even if they have to be in the presence of a representative of the child welfare authorities.
Thank you.
Yeah, and also just to finalize, also the MEP, I don't know the names, unfortunately, I cannot see the names, the gentleman that left. I would like to thank him for his intervention, because he did recall that, in fact, unfortunately, the law is at the moment what it is, and we cannot take it on our hands. So if there is a convention that has been agreed at international level by several countries, we cannot, even if we think morally and ethically that we are justified to take our child away because we have a case of violence. Unfortunately, if we do that, then we are faced with abduction proceedings. So it is perhaps best to check with some expert before we act as we think things should be done, because sometimes the laws do not agree with what we think. So it's best to avoid.
Thank you so much. Thank you. Now, I would very much like to thank the petitioners for their presence here, the members that participated in this discussion, the representatives of the Commission who somehow told about their difficulties in approaching gaps in legislation. In conclusion, the coordinators will prepare, in other cases, in the letter to Mrs. Reding, the Commissioner, not only the British cases will be highlighted, but a pressure to the Commission to rethink the ways in which such difficult issues as those discussed today are going to be solved immediately or very quickly. Otherwise, the European idea is endangered. So I give the chair to my colleague here, and thank you for coming.
Muy bien. Vamos a ver, hay una petición.
Let's see. I'm going to ask our colleagues, since I've been told by the Secretariat that currently there is a petition, or a group of petitions rather, concerning the theft of newborn babies in Spain, but I think that the petitioners are not present. Our colleague, for the next petition number 17, that is a petition concerning a construction of a landfill site in the Yambol region in Bulgaria. So we could move that one ahead on the agenda, and I'd like to ask my colleagues whether they will allow the speakers concerning the Bulgarian issue to take the floor.
¿Quieres? Muy bien.
No, presidente, no, yo lo que quería es dejar lo siguiente claro. El problema de las peticiones de los niños robados, que es del punto 16, que se han acumulado todas las peticiones de distintas personas y asociaciones sobre un hecho muy grave que ocurrió en España desde el 39 hasta el año...
No hay
interpretación.
Las tienes detrás, Billy. Que da el micrófono.
A ver.
Cambia el micrófono, Billy. Toma este.
Okay, the system failed and now restarted, so it should work. Now can you hear me? So I was saying that item 19 involves a group of petitions by various associations that are fighting a democratic struggle to denounce a very grave event that has been taking place in Spain from 1939, the end of the Civil War, until the beginning of democracy in the 1970s. And this is a systematic theft of children. In some regions, there has already been legislation saying that this is one of the crimes of the Franco regime. The problem is that the petitioners are not here. There seems to have been a problem coordinating things with the petitioners. So what we need to do is to make a commitment that the issue will be dealt with in the presence of the petitioners. So we need to make this official. I don't know if that can be done in this legislature, or in the next petitions committee meeting, we should invite the petitioners so that we can deal with that subject. All right, so we have Mr. Mayor's proposal that this petition be postponed until the petition can be dealt with in the presence of the petitioners. Now, Mr. Garces, you have the floor. Well, I'm not against what Mr. Mayor says, but I would have liked to speak on this point. If we deal with this issue, I would like to speak on it.
Mire, señor Garcés, aquí tenemos que determinar si tratamos el punto o no tratamos el punto. Si tratamos el punto, entonces se trata con todas las consecuencias y los peticionarios. Si no, tenemos que esperar. La cuestión es que no se vuelva a repetir varios puntos. O sea, está claro. O lo tratamos ahora.
Doy mi opinión.
Pero lo tratamos ahora sin peticionarios o lo tratamos con peticionarios la próxima vez. Entonces, ustedes me dirán, señor
Ilja, para argumentar por qué tienen que estar los peticionarios, yo quiero intervenir.
Si eso es una cuestión de orden, sí, porque tienen que estar peticionarios, me parece muy bien como ha hecho el señor. A ver, que hay problemas con la traducción. There is a problem with the translation. Yeah. A ver si los servicios los servicios de la sala pueden...
Es un problema técnico.
Vamos a ver, señora Zdanoka, ¿me está escuchando ahora? No hay.
Toma.
Vamos. ¿Me oye con este micrófono? Señora Alan Zdanoka.
All right, Mrs. Zdanoka, now the translation should be coming through. Interpreting should be coming through. It's not an issue of the microphone. The system restarted itself. All right, I'll use this microphone then. Mr. Garces, I've been asked to give you the floor on this point, so we'll hear from you and then we'll make a decision. So please, go ahead.
Translation I will do in English. I support the proposal of Mr. Meyer. I think that we should postpone the discussion of this point to a further meeting of the committee.
Muy bien. Le voy a dar...
All right. So I will give the floor to Mr. Garces, but just for 1 minute, because we're not going to open a debate. Just please explain your reasoning immediately. All right. Excuse me, actually, ladies first, if it's an issue of courtesy. I also agree that we postpone this to have the petitioners present, but we should also clarify things because the petitioners had the impression that they were not invited. There is a misunderstanding that needs to be resolved, specifically so that we don't have leave the impression that the Parliament did not invite them. So we just need to solve this issue. Thank you, Mrs. Ayala. I will give the floor to the Secretariat to explain or comment on what happened with this petition.
We have addressed...
Just a moment, please.
The Secretariat, as soon as the decision was taken to put this item on the agenda, contacted every single petitioner whose name is on the list, as well as representatives from the associations that we met only a few days ago, last week. They were all informed about this meeting, and some of them even were told that if finance was a problem, we would see if we could assist. We had no answer from them. So, on that basis, I'm afraid it is their responsibility whether they attend or not. We can't force them, but they were all certainly told. They were told about the timing and every detail about this event.
Muy bien. Señor
All right, Mr. Garces, please. Yes, thank you. On the same subject, 2 questions. One is more formal and the other one goes more into depth. I have in front of me the letter that was sent by the Secretariat to the Petitions Committee to Mr. Eduardo Raya. This is a letter with the date of March 3rd. And Mr. Raya is asked to provide a reply before March 5th concerning his presence at the Petitions Committee on March 19th. So there was very short time given for this communication. There wasn't enough time for a reaction or for a reply. So, for future reference, this sort of exchange of letters needs to be carried out, allowing more of a time frame to make it easier for the petitioners to be able to prepare themselves and be here in the petition committee as should take place. This is a formal point which I think is easy to solve if we are just more careful about the time frames and the scheduling issues for the committee and the agenda. Vicente, would you like the Secretariat to answer this question or go on to the next item, or what do you prefer?
Every petitioner was contacted, including those for whom we had their email address, were all contacted by email. It wasn't just a question of sending regular letters.
Vale. ¿Y segundo tema?
And the second subject? Yes, that's easy to solve for the future. Now, the second issue is more in-depth, because I have read the reply given by the Commission, and I would ask that for the next Petitions Committee meeting, I have a request to the Commission that in the next Petition Committee, when this issue will come up and the petitioners will be present here, I would like the European Commission not to limit itself to say that it is not competent and cannot deal with this issue. Rather, it's quite the opposite. I ask the Commission to make an effort to find the legal possibilities that really exist currently, and to make a technical, professional, legal effort to find the arguments against refusing to be involved. It's very easy to say we're not competent on this issue, it's up to the member states and we're not a court. But in a case like this, where there is so much information, where so much background is known, where it's already been proved in multiple ways that there is a real difficulty to get to the bottom of the subject in the framework of the Spanish state, then it is necessary for the Commission, by exercising and respecting the Charter of Fundamental Rights of the European Union, find the mechanisms that will allow it to intervene. And this is a specific request that we members of Parliament are making. Please, the Commission should not limit itself to saying that we're not competent. It needs to make a technical, legal, and professional effort to find the ways that will allow it to intervene where such possibilities exist from the legal point of view. That was my request for the Commission, so that in the next Petitions Committee meeting, when the petitioners will be here, that we can go further than the traditional negative attitude of the Commission. Thank you very much, Mr. Garces. Thank you for mentioning this point. This will be reflected in the minutes. And so let's go on to petition number 17, which is submitted by Mr. Dimitar Dimitrov, a Bulgarian citizen, concerning the construction of a landfill in Yampol, Bulgaria. Mr. Dimitrov, you have the floor. Where is Mr. Dimitrov? Okay, welcome. Welcome to the Parliament, Mr. Dimitrov. I just asked you to speak briefly because we're on a tight schedule. Thank you.
Je vous remercie, Monsieur le Président, Madame et Monsieur, membres du Parlement européen.
Thank you very much, ladies and gentlemen. We've been preparing ourselves for 3 years on this petition. I've got quite a lot of pages here, but I'm not going to read them out. What I'm going to try and do is to save some time. I don't think there's any point reading out a couple of pages of infringements. I think it's just sufficient for me to concentrate on the principal points. There are 2,600 signatures of the petition, and these are people who live in the neighbouring villages around this town, and they've said that this landfill should not be built in the proposed location. And the reason for that is this. In constructing this landfill site, there has not been a prior impact assessment carried out, and neither has there been any documentation provided in the way that it ought to have been provided. I know what the Commission said on this a year ago. It started off as a very small project, which was just to enlarge the Yambol landfill site, but from there an extra 148 towns and villages waste has been added, and this makes the whole project unviable. And it's going to be filled up on that basis in less than 16 months. So 15 million euros to solve the problem of the region for a period of less than 16 months duration. This is not what we would refer to as a sustainable long-term solution. We obviously have some proof because the Environment Ministry has already identified abundant clean water beneath the site, and I'm happy to give you this information in a separate file. I have, after all, promised to keep my oral presentation brief, but there has been an old environmental impact assessment, but it didn't take into account the fact that only 170 meters away from the landfill site is a dwelling, and I think nothing else needs to be said really to illustrate the fact that the proper work hasn't been done, and this is a proposed undertaking which threatens the well-being of our community. it's a kind of mafia operation to launder money or steal money, and it will be to the detriment of all our health. So, once again, there hasn't been an impact assessment, an environmental impact assessment carried out, as there should have been. An old environmental impact assessment was provided, and there are documents that have been submitted, and then there are those documents which are missing. I hope I've been sufficiently brief and to the point, and hopefully I've lived up to the job for which I was sent here by the community.
Thank you very much. And now I would like to ask the Commission to speak.
Chair,
Yes, and it contradicts what the Commission
we have received numerous complaints, informations, not only from the petitioner, but also from honourable members of the Parliament concerning this project for the construction of the landfill in Yambu. As already communicated to you and to the complainant and to the petitioner, so far we are not able to find any indication for breach of the respective European acquis requirements with regard to environmental impact assessment, with regard to waste management, with water. The assessment was already submitted to you. We are also ready to further provide you our observations on today's speech of the petitioner. I would just like to open a bracket and say that concerning the environmental impact assessment and the no existence of environmental impact assessment, yes, indeed, there is an old environmental impact assessment, and according to the Bulgarian legislation, it is still valid. And with regard to its application, I know very well the provisions concerning the Environmental Protection Act in Bulgaria, and your claims that it is still not valid. I would just like to say that there is a confirmed practice also by the European Court of Justice that for environmental impact assessments that were carried before the date of entry into force of the European legislation, for Bulgaria this is 1st of January 2007, the European Commission is not in position to launch any proceedings. Thank you.
Thank you. Our colleague has asked for the floor.
Thank you, President. I know Mr. Dimitrov. I had visited the site. This landfill is a project of the Ministry of Environment in Bulgaria and the Yambil municipality. The citizens of this area do not agree to this landfill. 170 meters away from the houses of people is where it is. I think this plot obviously is of great interest to somebody to grab. I hope the Commission understands me, because if somebody comes and throw their waste at 3 or 100 meters from your house, each and every one of you would react. Why am I saying this? Because the information that you receive from the Bulgarian authorities is incorrect. It is not possible for them to have concluded any type of assessment or to have met the norms if the waste is in front of people's homes. And this is no precedent. This has been happening in other places, in German, in Banja, in Rakitnica, these Bulgarian villages. I talked to the Deputy Minister of the Environment and Water, and he told me there is no forest there. And I told them, you don't need to visit a place. You just click on Google Earth and you will see that there's a huge forest. He told me, no, this is not possible. There are experts who told me there are no forests there. So don't become part of the lie that they're selling you. You should check the documents of Mr. Dimitrov. You should check the documents that you've been given by the ministry, because I do believe they're lying to you and they're lying to the population there, and thus distrust is created in institutions. All of these years here, the European Commission has been saying there's no breach, we cannot intervene, we do not have the prerogative to intervene. When local authorities are sending you information, you should check it, and then you should punish them if they're lying, because there are breaches of the law. Do not roll your eyes as if I'm saying nonsense. I live in this country and I know that legislation in Bulgaria is not observed. No other European country will allow what is happening in my country. These people are not here to criticize the European Union. No, they've come here because they expect justice. They expect to be helped because nobody in Bulgaria will help them, unfortunately. So that is why they're here. They're not here to criticize us. They're not here to point a finger. No, they're just asking you to help. They're asking for help. What will happen if somebody throws their waste in front of your house? How would you react? And then the authorities say everything is okay, everything's been done. These are European citizens, ladies and gentlemen. Once and for all, the European Commission should show them that it has the strength to defend its European citizens and not to defend virtual interests of the Commission itself. Please, let's return the faith in these people and the European institutions. Please give the floor again to Mr. Dimitrov because he wanted to go into the details. Please let him speak from his heart because I know that his heart is bleeding right now because he's lived in Europe. He's here to invest. He has a very nice house in the town of Yambol. And in front of his house, there are people who've built a landfill full of waste. This is a short-term landfill, but these people just want to reduce the price of the land. They want to reduce the price of the land and then sell this land at a low price. I am Bulgarian, I know what's happening. Do not act bureaucratically. People will lose their faith in the European Union. Please do something for the Europeans. Thank you.
Gracias, señor Bref. Señor Jar.
Thank you. Mr. Yar, please.
Thank you very much. I'd just like to quote from the Commission's reply, and that, I think, means that they're dealing with this on an ongoing basis. Now, they say that the implementation of the waste project in the Yambol region is going to be looked at in particular in its second phase. It should also be noted that the approval for phase 1 of the project was before the Bulgarian accession to the EU, and the environmental impact assessment directive was not directly applicable in Bulgaria at the time, and therefore there has not been a violation of EU law. Now that, as far as I'm concerned, means two things. I would suggest, first of all, well, phase 1, the Commission is saying, well, we're not responsible. Now that doesn't mean that it's up to everybody to do exactly what they want, because the national procedures will come into play. So as far as that first part of the petition is concerned, we need then to refer this to the national authorities. I don't know whether there's a national petitions committee or ombudsman in Bulgaria, but we need to determine whether there's been a violation of the law. So that's the first question. The second thing is that if there is deception or lies or just an incomplete provision of information, and maybe the Commission has been incorrectly informed, we need to know where along the line that false or phony information has come to bear from Bulgaria. And the other thing that's been said is, and this is the Commission saying this, is that we're going to keep an eye on this project, at least in the implementation thereof. So, phase 1, Bulgaria responsible. And we need to make sure that the national laws were upheld in phase 1. But when it comes to the implementation, that would fall within the remit of EU law. So we've got, what have we got? We've got the Water Frameworks Directive, we've got the Habitats Directive, the whole lot of it. So when it comes to implementation, we do need to keep an eye on laws not being infringed, and they must provide information. Now, the petitioner said that EU law is being violated, and I think we need to look at that further. I don't think we can let the petitioner go home saying we can't do anything. I think we need to split up this Commission response. So first of all, we need to refer it back to Bulgaria for phase 1, but in phase 2, we are responsible and we need to look into it further.
Yes, our colleague, please.
Bueno, yo creo que como otras muchas ocasiones.
Well, I think that, like on many other occasions, the Commission, in its response, has washed its hands of the issue. That has happened with many petitions presented to this committee. There are some key points here. I think that the Commission, as is usual, is basing itself only on the information that is received from the state authorities, that is, the Bulgarian authorities in this case. So, until what point are we aware that of whether this information is correct, accurate, and true, or whether there's something missing? Or is it information that has some problems with it that we can't specify anything about? That's a problem in the Commission's arguments. Also, it's mentioned that European Union's funds are going to be used in this project. And since these funds belong to the citizens of the European Union, we need to supervise to make sure that these funds are being used correctly. And it seems that 13 million of European Union funds are going to be used in a landfill that is only going to be working for 16 months. This seems to be a completely exaggerated investment from any point of view. And so it's an issue of whether waste treatment needs to be carried out at this location. And then, as far as the environmental impact assessment statement, that's required if we have an impact assessment statement from 2012 or 2002, when the new project has ensued and that more people are going to be affected, this requires a new environmental impact assessment. I think that as the Petitions Committee, we need to ask the Commission to investigate fully what is going on here. What is the scope of this project? What is the accuracy of the information that they've been receiving? And so they should not cast a blind eye on what's taking place in Bulgaria. And the Petitions Committee should set up an investigative mission in Bulgaria, because this seems to be not to be the only case of inadequate management of environmental resources in Bulgaria. Thank you. Thank you. Mrs. Yotova.
Благодаря, господин председател. Към аргумент.
Thank you, Chair. I would like to add one more argument to what my colleagues said. This petition should be studied. The European Commission followed a highly formalized procedure requiring data from the national authorities. However, this project had been changed many times, and we do not know whether all the European legislation has been duly implemented. You have to keep it in mind that the European Parliament seems to be the only place where European citizens can look for protection, but in Bulgaria there is also some proceedings currently in our courts, and they have to do exactly with violations of the Waste Treatment Directive. We see in this case that the landfill is quite close to the houses of people, and we cannot accept this. At the same time, we know that the European Commission should be able to exercise more supervision. And it is for this reason that I would say that monitoring should continue, and we need a second opinion of the European Commission. We would like to know whether there were any violations and what can be done.
Después de haber oído a los parlamentarios.
Excuse me. We've heard from the fellow members. I will now give the floor to Mr. Dimitrov for 2 minutes. I'm going to give you the floor for 2 minutes, and then we will make our decision.
Je vais être encore une fois.
I'll be very brief. Let me just answer the lady from the Commission. She may be familiar with Bulgarian law, but in this particular case, it says that the 2002 impact assessment was able to run until 2005, but in any case, it expired at least 3 years ago since the new work started, so it's no longer been applicable. So it's been expired for at least 5 years, and I think that's a sufficient argument. No, there is no documentation, no impact assessment, not an old one, not a new one, nothing. Thank you.
Muy bien. Después de escuchado todas las partes.
After having heard from all sides, I'm not sure if our colleague wished to speak, so we will keep the petition open. Yes?
Just 1 minute. I'm sorry that Mr. Binet
Espera un momento, señora. Señora.
Please wait for 1 moment, madam. You asked me whether there had been a reply. Did Mr. Yad ask for the floor?
Ich wollte schon einen Vorschlag machen.
I just want to make a suggestion. This is going to remain open, but we shouldn't forget that. But I would like to ask for part 1, stage 1, the authorization and the environmental impact assessment and so on. We know that there's a petitions committee in Bulgaria, so we'd like to give that to our partner parliament. Perhaps if there's a petitions committee there, or we could have a position, an opinion, not from the government, but I'm just saying that we should contact, as MEPs, the MEPs in the other parliament and look at the issue here, and we can work out whether the legislation is still valid or what is the case. I think we should try to make sure we get an answer, so we should work together with the parliament, a question from our parliament to the other Parliament, and we could see what the Bulgarian Parliament thinks about this, and of course we could involve the petitioner. That would be very helpful, and I think we would make sure that it didn't get lost from sight.
Yes, thank you. I now give the Commission the floor as requested.
I'll be very quick. There are 2 issues that are being mixed here. First are the existing landfills and the non-compliant landfill, in particular in Yambol, for which the Commission has already taken measures, because 1 month ago the Commission decided to refer Bulgaria to court with regard to the 114 non-compliant landfills in Bulgaria. So this is an ongoing case. With regard to the new project that the petitioner is claiming is not compliant with European legislation. For phase 1, I already explained that the environmental impact assessment, as part of a multi-stage procedure for issuing development consent, was finalized in 2012 with the issuance of the construction permit. So therefore, the EIA was still valid. For phase 2, once phase 2 is launched, because up to our information, it is not yet launched. We are going to very carefully follow it. With regard to the EU financing that is involved, this is a non-major project. This is a project that is within the responsibility of the managing authority of the respective operational program in Bulgaria. However, because of the numerous complaints that we have received, we have very carefully examined this project together with our colleagues responsible for the management of EU funds, DG Regio, and so far we are not able to identify any particular breach also with regard to the use of EU funds. As I said, the Commission is going to provide a detailed reply to the speech of the petitioner and the claims of the honourable members of the Parliament. Thank you.
Muy bien.
All right. In that case, I have heard all sides, and it seems that we are going to send a letter to the Bulgarian Parliament, and I'm going to ask Mr. Yar to contact the Bulgarian Ombudsman to obtain an opinion on this issue. The petition continues to be open, and since there is new information that has been brought by the petitioner, we will ask and demand the Commission to study it and send us some information about what it thinks of the information produced by the petitioner. In the meantime, we will see which steps need to be taken based on the information that the Commission will give us concerning the new information provided to us by the petitioner. Do the members agree with this? In that case, let's go on to the next item on the agenda. That's item number 18. A petition presented by Sheila Ellis, a British national, on behalf of Residents Against Toxic Site, bearing 7 signatures concerning the alleged failure of the UK to implement the EU directive on the landfill of waste. Is Mrs. Ellis here? Is she present?
Please.
Thank you. And hello, ladies and gentlemen. Colin Wakefield, Chairman of the Residents Against Toxic Site, and myself as lead petitioner are pleased to have the opportunity of speaking to you again. However, we are disappointed that as yet no action has been taken against the UK government and its Environment Agency for allowing the poisoning of the environment of the little town of Houghtonleigh Spring in North East England. As we have explained before, a monstrous landfill site festers deep within the water supply rocks in the middle of the town, less than 200 metres from homes and the town centre. We have also explained that it has caused our town to be plagued with flies, vermin, litter and unimaginable stench. These have now largely ceased as soils have been landfilled on top. But the tip produces large amounts of dangerous gases from the putrid rotting waste, which includes sewage sludge and waste food from 500,000 people, as well as dangerous chemical waste from industry, which has been transported to be dumped in Houghton from many parts of the UK. The result of the fact that the site was not designed or properly lined to sit within our water rocks is that our water is now heavily polluted, up to 90 times the permitted amount. This is one of the UK's major aquifers, and it is being ruined contrary to landfill and groundwater regulations. The UK central government allowed this to happen. Local government, Sunderland Council, gave it planning permission because they wanted to dump all of Greater Wearside's waste in it and didn't care about the consequences. Since then, the authorities have done nothing but cover up and tell deliberate lies. The only prosecution over water pollution was to try to get the UK Environment Agency out of trouble with the EU. Along with the site operator, it pretended it was a one-off incident when it privately admitted that it was a continuous leak. Last time we were here, the EU officer told me that it's not about punishing the UK. Well, it should be. We have suffered for nearly 20 years, and the water supply for some 500,000 people has been poisoned. It's about time the UK was held accountable for ruining our environment. We are relying on you to force a clean-up of this site and remedial measures to stop further pollution. We are also relying on you to prosecute the UK for its cynical disregard of environmental legislation, being untruthful to this committee, and leaving the citizens of Houghton to suffer. Thank you very much.
Thank you very much, Madam. So I'm going to give the floor to Madam Civil Cross of the Commission.
Mr. President. I will try to address two issues. The first is the situation at the site as it is now, and the second is the request by the committee and also the petitioners for the Commission to start infringement action. The committee has been aware that this petition, which was registered in 2005 and on which the Commission already had a complaint over in 2002, the key concern was always about groundwater pollution and its potential because of the instability of the land underneath the landfill site and the nearby drinking water aquifer. When we originally investigated this site, that was our key concern, and also that of the complainants and the petitioners. As a result, we asked the UK authorities to carry out a survey of the site, which through an independent assessor, which they did through the British Geological Survey, and that at the time showed that there were no systemic problems of groundwater pollution. After that, other issues have been investigated and arisen. The main one to which the petitioner refers is the odour and litter nuisance that they suffered from. The site has now been fully capped for some time, and those nuisances have reduced. However, the UK have informed us that the more recent groundwater pollution evidence that has arisen since 2009-2010 resulted from an illegally built haul road across the site. This in itself, we were told, initially resulted in localised pollution of the site with ammonia levels with high readings, but control monitoring around the site not showing that the pollution had spread. The UK informed us that they were preparing a prosecution, which took some time, but the prosecution was successful and the company was fined £130,000. They are also required to remediate the pollution, which at the time was the flushing out of the borehole and flushing hole on the site. Now, at the last hearing, where the petitioners were also present in April of 2013, we were told that there were concerns that the monitoring station downstream called Stonygate, which is the monitoring station that also monitors the drinking water quality, had been closed, and that this was a cynical attempt to cover up pollution having escaped the site and reached downstream to pollute the water aquifer. We were told at the time by the UK authorities that this was not correct because they had installed an intermediary monitoring site between the landfill and the drinking water aquifer monitoring station, and that was showing no pollution had spread. We understand more recently, however, that the assurances that we were given that there was no pollution spreading and that the pollution that was localised on the site was reducing, unfortunately, are not true. The pollution is now showing to spread from the site downstream, and although it hasn't yet reached Stonygate monitoring station, appears to be a concern that it may do. So the local authority, the local Environmental Protection Agency, is now in the UK very closely monitoring with the water company the spread of the pollution. As far as the second point is concerned, the opening of infringement action, the committee and the petitioners have asked the Commission at numerous occasions to start infringement action. The petitioner has also stated that she feels it's unfair that the Commission has started infringement action against other Member States, but not in this case the UK. I think, as my Bulgarian colleague explained, we have started numerous infringement actions under the Landfill Directive, but they tend to be aimed at systemic breaches, and they tend to be aimed at illegal landfills without authorisation, or landfills where the local regulator is incapable or not acting to deal with pollution. To date, this landfill has not fallen into that category. However, the more recent information we are now receiving, and the latest information I think this committee received was from January, I have some more recent data from February, is of more concern, as it appears that groundwater pollution is spreading. I'm sure it gives the petitioner no pleasure to say, we told you so. But as far as the Commission's powers of infringement are concerned, we can only act when there is evidence of actual breach, not on evidence of potential and likely breach. The Commission will continue to keep this case under close review. One other question we would have for the petitioner also, but maybe we can discuss that bilaterally, is that so far all the enforcement action by the authorities have been through criminal law. There have been 2 criminal prosecutions of the operator and requests for clean-up in that context. But we also have a civil environmental law liability directive which gives local residents powers and environmental groups powers also to follow up on remediation under environmental liability. Thank you.
Thank you very much. ¿Alguien quiere intervenir?
Did anyone wish to speak? The petitioner, for example? Yes, Mr. Yap.
Before you, I'm going to give the floor to the member, and after the member, you can tell us what you want. Okay.
Well, I must admit that I'm a little bit irritated here because I think the Commission has said that the pollution continues, we've still got contamination, that's quite worrying. And it's not being tackled properly, and the infringement procedure isn't enough. So my question is, well, there's a first step, a pilot stage, and you have to stick to that, of course. But if something isn't right,